and loudly. When needed, Ms. Mosk or a panel member will interject to ensure a proper transcription. After the hearing, Ms. Mosk will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The Office of Tax Appeals is an independent appeals body, which is independent of any tax agency. While the Office of Tax Appeals is not a court, we must nevertheless follow certain guidelines to ensure that we establish a proper record on which a decision is based, and we conduct an orderly hearing. Each party will have the opportunity to be heard, so please wait for your turn to present your side. Also, I may interrupt the hearing if necessary to keep us on track and create a clean and efficient hearing record. Are there any questions about anything I've said before we go on the record?
No questions. Thank you.
Thank you, Mr. Cotino. And for appellants? Mr. Colabianchi? Mr. Colabianchi, I believe if you press *6, you can unmute yourself. Just want to see if you have any questions at this time. Did we lose Mr. Colabianchi? I don't see him now. Mr. Scholler, I see you're there. Do you have any questions?
I do not.
Okay, thank you. And so you can mute yourself again, but I just want to make sure. It looks like we lost Mr. Colabianchi, so our team is going to work on getting him back on. When we do a virtual hearing, we do have to kind of anticipate we might have these little technical glitches. No problem. We just roll with it and keep going. Why don't we just call a little maybe 5-minute break so that we can make sure we have everyone here. I'm going to ask that everyone go ahead and mute themselves and turn off your video, and we will be back at 9:52. Okay, we're back. Please go ahead and turn your video back on, and you can stay on mute for now. As I had mentioned, we have a stenographer with us today who will be transcribing this hearing verbatim. So please speak one at a time, not over each other. And just a reminder that Office of Tax Appeals is an independent appeals body, and we are independent of any tax agency. While the Office of Tax Appeals is not a court, we will nevertheless follow certain guidelines to ensure that we establish a proper record on which the decision is based. So I might interrupt from time to time just to keep us on track, make sure that we're not speaking too quickly or over each other, and just ensuring that we have a clean hearing record. So I wanted to check if there are any questions. Mr. Cotino confirmed he had no questions. So Mr. Colabianchi.
I did have a couple questions. So first of all, we had submitted some proposed additional exhibits past the deadline.
We will get to that.
We'll get to that. Okay. So
Yeah.
this is more like a...
Do you have any questions about what I just said?
No.
Okay, great. So we will get to those type of procedural and more substantive questions. Thank you. Okay, so I'm just going to make sure that everybody is ready to proceed on my end. I will check in with Ms. Mosk. Are you ready?
Good morning. I'm sorry, my dog's barking. Yes, I'm ready.
Thank you. And now I'll check in with my panel members. Judge Aiken, are you ready to proceed?
Yes, I am. Thank you.
Okay. And Judge Kletter, are you ready to proceed?
Ready to proceed. Thank you.
Great. In that case, we are going on the record. This is the appeal of Scholler, OTA case number 200-56173. The date is September 27th, 2024, and the time is 9:54 a.m. This hearing is being held electronically with the agreement of the parties. I am Judge Vasig. I will be the lead judge for the purpose of conducting this hearing. My co-panelists, Judges Aiken and Kletter, and I are equal participants in deliberating and determining the outcome of this appeal. I'm going to ask the parties to identify themselves and who they represent, starting with the Franchise Tax Board.
Good morning. My name is Brad Catino, and I represent Respondent Franchise Tax Board. Thank you.
Morning, thank you. Okay, and for appellants, who do we have?
Good morning, Your Honors. This is Mauro Colabianchi. I represent appellants Scott and Gay Scholler.
Great, thank you so much. And I believe that we saw Mr. Scott Scholler here today.
Yes, I'm Scott Scholler. I am the taxpayer.
Right, and is Gay Scholler also here today?
She's in the waiting room.
Okay, that is fine, thank
Yes.
you. All right. As stated in the minutes and orders, the issues to be decided in this appeal and that the parties have agreed to are: one, whether appellants are entitled to a bad debt deduction for the 2003 tax year. Two, whether appellants are entitled to a worthless stock deduction for the 2003 tax year. Three, whether the accuracy-related penalty should be abated. And four, whether any interest should be abated. I'm going to move on to our exhibits. I know we have a bit to discuss in that regard. Appellant had submitted exhibits 1 through 14 after the pre-hearing conference. Franchise Tax Board did not object to the admissibility of these exhibits, and therefore appellant's exhibits 1 through 14 are admitted into evidence at this time. And we'll get to appellant's recent proposed exhibits. But I want to mention first that FTB submitted exhibits A through H and exhibits L through O. It should be noted that FTB did not submit exhibits labeled I, J, or K, and I decided not to relabel the exhibits following exhibit H in order that any references to exhibits remain consistent with that in the briefing. So that should avoid any potential confusion. Appellants did not object to the admissibility of these exhibits, and therefore exhibits A through H and exhibits L through O are admitted into evidence. So earlier this week, appellants proposed additional exhibits 15 through 18. These were a late submission. Proposed exhibits 16, 17, and 18, to my understanding, were in the possession of a witness, Mr. Ralph Bagley, who recently found them in a mislabeled file. So appellants did not have possession of those exhibits until recently. Proposed exhibit 15 was not earlier submitted due to a miscommunication between Mr. Scholler and his representative. Do I understand that correctly?
Yes, Your Honor.
Yes, I think so. That sounds right.
Okay, so I've determined that that does not qualify as good cause for the late submission, but we can discuss exhibits 16, 17, and 18. I want to check in with Mr. Cotino. Does FTB have an objection to the admittance of proposed exhibits 16, 17, or 18?
Yes, respondent does object to those exhibits. As stated in the pre-hearing conference minutes and orders, the deadline to submit additional exhibits was September 12th. This was an extension from the September 3rd deadline due to the moving of the hearing date. The exhibits were received on September 25th, almost 2 weeks after the deadline stated in the pre-hearing conference minutes and orders. And thus, respondent does not have sufficient time to evaluate the evidence presented, evaluate it, and determine the veracity of it and how it may alter its position. And for those reasons, respondent objects to those exhibits.
Thank you, Mr. Cotino. If these exhibits were to be admitted, would FTB like post-hearing briefing? We can't hear you.
Sorry, I clicked the wrong button. Yes, in the event that these exhibits are admitted, again, respondent objects to the admission of them, but in the event that they are admitted to the record, respondent would then request post-additional briefing.
Okay, Mr. Colabianchi, can you please speak to your argument that there is good cause for the late submission of these proposed exhibits?
Yeah, so for these exhibits, based on our knowledge of the records of the company at issue here, we believe they had been destroyed previously. Mr. Bagley, when he was reviewing some files he had to refresh his recollection, it was in an unrelated folder. I believe it was having to do with the development of the software. Scott, can you correct me if I'm wrong on that?
Yeah, he was looking for these exact dates of release for each of the game titles. And the software you keep is you have a gold copy, which is kind of the master from which games are replicated. And so that was where it was labeled, but a backup file had been made, and it happened to include those items. So if he hadn't have been looking for specific dates on the release of the games, probably never would have noticed them.
Okay, thank you. Mr. Colabianchi, anything else to add?
No, I don't believe so. Just one thing, that these are it includes a balance sheet and a profit and loss statement. So these would be financial in nature, and you wouldn't expect them to be in this kind of folder where it's discussing about the folder happened to do with the development of the software specifically.
Okay. It looks like the panel has come to a decision on this. Since the exhibits were not in appellant's possession and were recently discovered, for good cause, we are going to admit exhibits 16, 17, and 18 into the record. And we are going to allow FTB post-hearing briefing to address those hearings if FTB finds that necessary. Okay. Appellants indicated during our pre-hearing conference that they will be presenting testimony or written declarations from the following individuals: G. Scholler, S. Scholler, Dave Caputo, Doug Dietrich, Chris Perkins, Dan Hildebrand, Chris Lavelle, and Ralph Bagley. FTB did not raise objections to any of the witnesses. Before we begin appellant's presentation, I will place, well, actually, I remember we had a request this morning that each witness be sworn in individually. So what we were going to do is, Mr. Colabianchi, you have 15 minutes for your opening presentation, and then you will have up to 2.5 hours to present witness testimony. I will swear in each witness before they testify, and they will remain under oath until the close of this hearing. Mr. Colabianchi, you can have the witnesses testify in the narrative form, or you may ask them specific questions. And please proceed when you are ready.
Okay, well, thank you, Your Honor. As parties know, this case is about a short-term loss claimed on the Scholler's 2003 tax return. The loss originates from a non-business bad debt deduction of $1,233,460. The bad debt this refers to is a series of short-term loans given by Scott Scholler to a company called Enlightening Software Development Incorporated, or NSDI. NSDI was in the video game business, specifically targeting Christian, family-friendly market. While initially successful, NSDI ultimately closed in 2003. NSDI was unable to repay the loans Scott had made to it, and Scott therefore took the bad debt deduction. While this deduction was ultimately disallowed by the IRS, we intend to show that this deduction was properly taken, and only through a series of miscommunications did the tax to become final with the IRS. prove that this deduction was properly taken, we must first show that the Schollers did indeed transfer funds to NSDI. We will hear testimony from NSDI's former CEO, Director of Marketing, and others to corroborate these payments. We have also submitted wire instructions and bank statements into the record to prove these payments took place. Secondly, we will show that these loans qualified as bona fide debts. Under federal tax law filed by California, a bona fide debt is a debt which arises from a debtor-creditor relationship based on a valid and enforceable obligation to pay a fixed or determinable sum of money. For a debt to qualify for the bad debt deduction, it must have been a bona fide debt. I'd like to clarify that there were in fact 3 lending events with NSDI as the borrower and Scott Scholler as the lender. The first lending event started in 2000 when Scott agreed to loan just under $850,000 to NSDI.
Oh,
It
Okay,
appears that
show-
we have lost Mr. Bianchi
he's
again.
back.
I apologize. I'm having some technical issues on my end. Wasn't having them before this morning, so bear with me. Again, I'm sorry.
Mr. Colabianchi, why don't we try turning off your video so that maybe we're not taking up so much.
Yeah,
Bandwidth.
it's jumping, so your bandwidth seems low.
Okay, I
And
could try that.
okay,
see.
I'm just gonna also let the parties know that we're going to take a break at the 90-minute mark. So I will give you a little heads up when we hit that point. And if someone is testifying, we'll let them finish their sentence, train of thought, and we'll take a little break at that point. Okay, Mr. Colabianchi, back to you.
Okay, thank you. Can you hear me?
We can
Yes.
hear you.
Great. The first lending event, thank you. The first lending event started in 2000 when Scott agreed to loan just over $850,000 to NSDI. These loan disbursements were ultimately made in 2 installments, one in 2000 and one in early 2001. This lending event was not included in the calculation of the bad debt deduction. However, we will ask the witnesses about this loan in order to show that there was a lender-borrower relationship between Scott Scholler and NSDI. The second lending event started in June 2001 when Scott agreed to provide short-term loans to the business to help with the development and marketing of its second video game title. These loans ultimately equaled approximately $800,000. This loan was included in the calculation of the bad debt deduction. The final lending event has to do with an unsecured line of credit provided to NSDI by Home Valley Bank starting in September 2000. This line of credit was renewed in 2001, and the interest rate was reduced in early 2002. In June 2002, Home Valley Bank was sold, and the new owner, on very short notice, less than 30 days, directed that all lines be called, which included the line of credit with NSDI. Scott Scholler refinanced this line of credit of $400,000 and stepped into the shoes of the bank. We will show using objective indicators that both the second and third lending events were bona fide debts in that they, number one, had the correct form of the instrument to be considered a loan, interest was charged, and promissory notes were drafted. There was a board meeting to memorialize the agreement. Number two, the intent of the parties was that these payments would be loans. NSDI all intended to repay the loans, and Scott intended to be repaid. The objective, number three, the objective and economic realities show that this was a loan. First, NSDI secured a third-party lender, Home Valley Bank, showing that third parties would indeed loan to NSDI. And second, at the time of the loans, there was a reasonable expectation that NSDI sales would be at a level to fully repay Scott Scholler. Counsel for respondent has argued that Scott's transfer of these funds was a gift or paid in capital. Scott received a 20% interest in the company as incentive to provide NSDI with the first loan of just under $850,000. The granting of shares as an incentive to provide debt financing was an often used practice by startup companies. This agreement was drafted by Roger Rappaport, who headed up the emerging growth and venture capital practice at Procopio. However, these loans were not included in the calculation of the bad debt deduction. They weren't part of the deduction. The short-term loans Scott provided starting in June 2001 were not connected to the first loan agreement, and these make up the bulk of the debt that was written off, over $800,000 worth.
Mr.
Last
Colabianchi,
element
sorry,
that must be,
Mr. Colabianchi.
yeah,
That last sentence, you were
sure.
kind of in and out, so can you repeat the last sentence, please?
The short-term loans Scott provided starting in June 2001 were not connected to the first loan agreement, and these make up the bulk of the debt, which was written off, over $800,000 worth. The last element that must be proved is that the debt at issue was worthless in the year that the deduction was taken. In our case, the deduction was taken in 2003. We have several objective, identifiable events which point to the debt being worthless in 2003. Number one, the sales of NSDI's highly anticipated second title were lower than expected, and NSDI was unable to secure distribution agreements for their product. Number two, Michael Acton, a person NSDI contracted with to provide accounting services to the company, was discovered to have embezzled more than $115,000 from NSDI. This discovery happened in May 2003. Our witnesses will testify how this embezzlement damaged the business. Number three, due to the lower sales and revealed embezzlement, NSDI let go of its entire staff in September 2003. IRS records will prove that 2003 was the last year that NSDI issued payroll. Number four, a letter from CEO Ralph Bagley to Scott Scholler dated September 22nd, 2003, states that NSDI will not be able to repay the debt to Mr. Scholler. These events taken together show that NSDI's debt to Scott Scholler was utterly worthless in 2003, and therefore it was proper for the Schollers to take this deduction on their 2003 return. In conclusion, these debts were bona fide and worthless in 2003. They were properly written off as a bad debt in 2003. Moving on to the penalty. Under Neonatology Associates versus Commissioner, U.S. tax court case, taxpayers will not be held liable for accuracy related penalties if they relied upon their tax professionals for their reporting positions. The tax court set forth a three-pronged test for taxpayer to show reasonable reliance on a tax professional. First prong is whether the advisor was a competent professional who had sufficient expertise to justify reliance. Second prong is whether the taxpayer provided necessary and accurate information to the advisor. The third prong is whether the taxpayer actually relied in good faith on the advisor's judgment. We believe this test has been met by my client, and thus he should not be held liable for the proposed accuracy-related penalty. My client discussed the bad debt deduction with a financial advisor, Richard Berry, and he reasonably relied upon his advice when he claimed it in 2003. Therefore, the accuracy-related penalty should be abated. Regarding the interest abatement, Franchise Tax Board issued a notice of proposed assessment to my client in 2009, and it was timely protested. My client was still trying to have the IRS reconsider the outcome of the IRS's prior audit, and therefore the Franchise Tax Board granted him time to try to obtain this reconsideration. However, the last time the FTB issued a letter to my client before the notice of action in 2020 was in 2016. We believe this is attributable in whole or in part to unreasonable delay on the part of the Franchise Tax Board. No significant aspect of the delay after 2016 was due to actions attributable to my client. The FTB could have issued the notice of action at any time. The error also occurred after the FTB first contacted the taxpayer, as the notice of proposed assessment was issued in 2009. Therefore, we believe the interest from 2016 through 2020 should be abated. That ends my opening statement. Thank you.
Thank you, Mr. Colabianchi. I'm going to turn to my co-panelists to see if they have any questions for you. I'll start with Judge Clutter. Do you have any questions?
This is Judge Clutter. No questions at this time. Thank you.
Okay. Judge Aiken, do you have any questions?
Also no questions at this time. Thank you.
Okay, I do have one question, Mr. Colabianchi, regarding the accuracy related penalty. You mentioned that appellants relied on the tax professional for this position. Is there any documentation of that legal position?
I don't believe there would be a written legal position by Mr. Berry in the record.
Okay.
Scott, do you have any, could I ask Scott if he might have any input on that?
Yeah, no, I'm not sure I quite understand the question regarding
So when you spoke to Mr. Berry about the bad debt deduction, did he issue any kind of opinion letter that you should take the deduction in 2003, or is there any other documentary substantiation about that?
Maybe I haven't been looking for that. I mean, there's a lot of correspondence between ACO Asset Management, Richard Berry, and myself at around that time.
I'm going to stop us right here because Mr. Scholler is giving testimony. So I'd like to
Okay.
swear you in so that
All
we
right.
can consider what you're saying as part of the record. So can
Okay.
you please, at this point, raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, so Mr. Scholler, you are sworn in and you will remain under oath for the remainder of this hearing, and you may proceed answering the question. What I specifically want to know is, do you have any documentation, any emails or a letter from the tax preparer documenting that this was the position that
I
they?
may. It would take me. It would probably take me a few minutes to figure that out. Maybe when we take a break, I will attempt to do that.
No, it's okay. It's just asking if it's
Yeah.
already in the record. Okay.
However, the meeting where that was discussed was in tax preparation for the year 2003. As he did every year, Richard would come to our home, and it was around the kitchen table with myself, Richard, and my wife, who will be providing testimony later. So,
Okay, thank you. Mr. Colabianchi, who would you like to call as your first witness? Mr. Colabianchi, can you unmute?
Yes, I'm back. I think I'll try to call in if that's all right with Your Honor. Could we
That
maybe
is
have a
absolutely fine. Mhm.
could we maybe have a 5-minute recess to see if I can work through these issues that I'm having?
That's fine. Yeah, we can do that.
Okay.
So if everyone can still, please stay on the Zoom, but go ahead and turn off your audio if it's on and turn off your video. And we'll see you at 10:23. Okay, looks like we're ready to start again. I'm just going to double check with Ms. Mosk that you are here and ready.
Yes, I'm ready.
Great, thank you. I want to check with you as far as the audio so far. Has it been clear enough for transcription? Ms.
Yes,
Moss?
yes,
Okay, great.
I've been able to hear everything so
Wonderful.
far. If I can't hear something, I will definitely speak up.
Thank you very much. And I would like to check in with Judge Clutter. Are you ready for us to proceed?
Yes, I'm ready to proceed.
Okay, and Judge Aiken, are you ready to proceed?
Ready.
Okay, Mr. Cotino, are you ready to proceed?
Yes, thank you.
Okay, and Mr. Colabianchi, hopefully the last of the technical issues you've been dealing with this morning, are you ready to proceed?
I'm ready. Thank you, Your Honor.
Great, so we are now back on the record. And Mr. Colabianchi, you were going to tell me which witness you would be calling first.
I'd like to call Scott Scholler first, please.
Okay, wonderful. My understanding is that available to us, we have Mr. Scholler, Ms. Scholler, Doug Dietrich, Chris Perkins, and Ralph Bagley. So if possible, I'd like those individuals to be sworn in together, just to save us a little time. So just going to check. You can unmute yourself by pressing *6 really quick. I think we have Gay Scholler. Just let me know you're here.
I'm here.
Wonderful. Scott Scholler, just confirm that you're still with us here.
Yes.
Okay, Doug Dietrich. And yet, Chris Perkins.
Yes, Your Honor, I'm here.
Okay, Ralph Bagley.
Yes, Your Honor, I'm here too.
Okay, and I do see Doug Dietrich on the line. So, Mr. Dietrich, can you press *6 since it looks like you're calling in, and just confirm that you can hear me? Okay, so I will swear him in later. For Gay Scholler, Scott Scholler, Chris Perkins, and Ralph Bagley, I ask that you please raise your right hand. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I swear.
I do.
I
Okay,
swear.
You.
thank you. You are under oath and you will remain under oath until the close of this hearing. Everyone but Mr. Scholler can go back to the waiting room, but I ask that each witness stay with us available in case there are any questions from the Franchise Tax Board representative or any of the panel members. So, Mr. Colabianchi, please proceed with your witness presentation.
Thank you, Your Honor. Good morning, Mr. Scholler. You
Good morning.
and the parties are aware this case. Morning. As you and the parties are aware, this case involves a question as to your deduction of over $1.2 million on your 2003 tax return. It's a non-business bad debt. I'd like to start with the background information to give the court an understanding as to your involvement with the borrower. And throughout this hearing, I will be referring to Enlightening Software Development Incorporated as NSDI. Can you please provide us with a summary of your business and professional background prior to and during the time you were a lender to NSDI?
Certainly. After graduating West Point, I served 8.5 years on active duty in the military. When I went off of active duty, I joined Applied Materials in the Bay Area. And over the course of the years that followed, leading up to when I provided loans to Enlightening, I was an executive in 4 startups and one turnaround of a failing company. Those 4 startups ended up, 2 went via merger. One is now a 30-year-old public employee-owned company. I said 4, it's 5. And 2 of them became public companies via IPO. So at the time that I was introduced to Ralph Bagley and Enlightening Software Development, I was in discussions with that 5th startup, which was Interlace Corporation. So any of you that have had LASIK in the in the last 20 years and then enjoying good vision, you're welcome. So, but anyway, so yeah, that's my background.
Great, Mr. Scholler. So you mentioned Ralph Bagley. I wanted to ask you about some specific individuals and how they are related to NSI. So who is Ralph Bagley? How did you and he first meet?
Ralph Bagley was the CEO of Enlightening Software. And I was referred, or he was referred to me by Russ Hall. Russ Hall was a classmate of mine at West Point. We were in the same year group in the same company, and he is the founder and managing partner at Legacy Ventures. I think it's now called Next Legacy. And so he knew me pretty well and thought that this might be something I was interested in. So that's how we met.
Okay, and I'll get back to that a little later when you said something you might be interested in. But I wanted to go through a few more names. Dave Caputo, are you familiar with that name?
Yes, Dave Caputo was the marketing and salesperson at Enlightening. I met him maybe once or twice.
Okay, and Chris Perkins, how did he fit in with NSDI?
Chris Perkins, I believe, was their project, the lead development project leader, I guess is the right term.
Okay, and Doug Detrick.
Doug Dietrich was a board member.
Okay, and then last name Michael Acton.
Michael Acton, aka the Embezzler, was a contract hire by Enlightening. I spoke with him a few times on the phone.
I'm sorry. I'm sorry to interrupt. I was put in a waiting room I've been trying to get a hold of someone for the past probably 6 minutes. So I can go back to the last information that I heard. And unfortunately, we're going to have to go over everything.
Okay, Ms. Moss, can you please tell us the last few lines you heard?
Okay. So it was Mr. Scholler giving an answer. Those 4 startups ended up, 2 went via merger, and 1 is still now a 30-year-old public employee-owned company. And then that's where we dropped at. So I don't know what happened, why my internet was okay. Someone put me in a waiting room.
Okay, so I think that you were put in a waiting room when the witnesses were put in the waiting room. My apologies for that. Mr. Colabianchi and Mr. Scholler, I'm going to ask, and I'm so sorry, but I'm going to ask that you present that testimony again, starting with where you left off that Ms. Moss heard.
All right, I think I can recall it all. So where I left off was 1 is now a 30-year-old employee-owned company. I misstated when I said public. It's an employee-owned company. And the last 2 became public companies via IPO. I was at the time that I was introduced to Enlightening. I was in discussions with that last company, Interlace Corporation, and I went off on the side, which I'll leave out this time. So, but so yes, that's my background.
Okay, thank you, Scott. I believe you mentioned Ralph Bagley. You may have mentioned it, but I'm going to ask you about some specific individuals, how you know them, and how they're related to NSDI. So the first name would be Ralph Bagley. How do you know him, and what was he to NSDI?
Ralph Bagley was the CEO of Enlightening. I was introduced, or he was referred to me by Russ Hall, who was a classmate of mine at West Point. We were in the same year group and company, so that's like 20 people. So we knew each other pretty well. After I was when he started out, he was at LSI Logic when I was at Applied Materials, so we kind of traveled in the same circles. And he knew me pretty well. And he's the founder and managing partner at Legacy Ventures. I believe it's now called Next Legacy. And Ralph had met with him. And while it wasn't a good fit for Legacy Ventures, he thought I might be something I was interested in. And so he referred Ralph to me.
Okay, and I'll get back to that, but I want to move on to a couple more names. Dave Caputo. So, are you familiar with that name?
Dave Caputo was in charge of marketing and sales at Enlightening. I believe we met once or twice.
Okay, and then Chris Perkins.
Chris Perkins was the project lead/lead developer for the Enlightenings's games.
Doug Dietrich.
Doug Dietrich was one of the original lenders to the company and a board member.
And then the last name is Michael Acton.
Michael Acton was a person that Enlightening contracted with to provide payroll and accounting services to the company. I spoke with him on the phone and exchanged emails with him on occasion, mostly related to loans.
Okay, man, I'll get back to him later. However, I'd like to go back to Ralph Bagley. He said you talked to him and he thought you might be interested in his business. So when and how was the pitch originally made to you to provide loans to NSDI, his business he was CEO of?
Okay. Early in 2000, January, I believe, and he came to where I lived in Poway, California, and introduced himself. Russ had already told me he would be contacting me, and so he presented his concept, their ideas. They had a demonstration of the software of the game, and told me that they were looking for debt financing to get the company going. Yeah, that was it. He had some other discussions about the market, the size, and that. As a Christian, as a parent, as a video game player, and as a parent of children who were video game players, I kind of understood the market a little bit, although it's not something I had ever dabbled in. His what they were proposing had a certain level of appeal.
Why was debt financing chosen rather than equity financing?
Well, in my experience and in early stage companies, specifically, at the seed or the what is commonly referred to angel phase of a business startup. Debt financing, loans is often the direction to go. I mean, you only have a concept. You don't have product, you don't have sales. Until you get to those levels, venture capital money isn't going to be available to you. The Since you don't have any of those things, what selling shares of the company, you're probably not going to. One is venture capital companies are probably not even going to talk to you. Second, if you would give up basically most of your shares of the company for probably not enough money to get you going. So, debt financing, even in large companies like when I was at Cymer, they had millions of dollars raised from who would be their customers, which were Nikon, Canon, ASML, and SVGL. And the form of that money was all in convertible debentures, basically loans that at a point in time in the future, the lender could choose to convert to shares at a predetermined price. But fact is they're loans, right? So, I'm familiar with debt financing as a vehicle in startups.
What was the form of the agreement? Was there a promissory note?
Yeah. They didn't have an agreement, so I said, well, I'll have Roger Rappaport, who was the head of emerging growth and venture capital practice for Procopio, Corey Savage, and Hargraves and Savage LLP. And somebody that I had worked with or had worked with companies I'd been in for some time. He prepared the agreement, which included that, that it was a loan and that it came with a stock grant and a seat on the board. So yeah, it's a multi-page document that you got there somewhere. So
the what was the interest rate? Do you recall?
Not offhand. I think, okay, as I recall, it was fairly high.
Okay. And did you expect to be repaid?
Absolutely.
When did you make the first loan and how much was it?
We in the document, it specified 2 tranches. The first tranche was in March, and it was for $400,000. Second tranche was slated for August, but then by mutual agreement, Enlightening allowed that it be broken up into smaller tranches. Oh.
Yep. Let me see. To your knowledge, after you provided loans to NSDI, these initial loans, did NSDI receive financing from any other sources?
Yes. In September of 2000, reached Enlightening reached agreement with Home Valley Bank to provide an unsecured line of credit, ostensibly for the acquisition of inventory, video games, and attendant materials like displays and so on. While I wasn't part of that negotiation, because I was the I was the lender, the first lender. I had to sign off on the agreement, or I was asked to sign off. I don't know if I had to, but anyway. So yes, they had an unsecured line of credit for $400,000 from Home Valley Bank.
Okay, I want to come back to this, but something regarding the first loan you made to NSDI in two payments. Did you include that in your calculation for the bad debt deduction? Was that included in the amount that was deducted?
No.
Okay. So returning to Home Valley Bank, what happened to this line of credit with them that NSDI had?
Well, it was renewed in 2001. Along the way, there were several times where they reduced the interest rate for the line of credit. Sometime in the early spring of 2002, they reduced the rate the last time, and Ralph, in one of the telephone calls, Ralph Bagley, the CEO, in one of the phone calls, indicated that they intended to renew the line of credit further, or that the VP in charge at Home Valley Bank had said that. But be that what it may, in June, Home Valley Bank was sold to another bank. I don't recall the name of it. And the new owner wasn't going to be in the business of providing lines of credit to anybody. So they called them all, which included Enlightening, and with less than 30 days notice, which, as you can imagine, caused a panic situation. So, because it had taken months to negotiate the first line of credit. So finding someone to replace him, was going to put a real strain on the company.
Can you describe a little bit more why the line of credit was canceled?
Yeah, they got out of the business. It wasn't because of non-compliance or anything like that. Is the new owner, the new bank, wasn't going to be, they were more of a retail bank, and they were getting out of commercial banking. And so the lines of credit, they just called them all to be paid out by the end of June.
Thank you. And then what happened to the line of credit after that?
Well, the company attempted to negotiate or find a new bank to assume the line of credit. But if you don't have a relationship with a bank, that's going to be pretty hard. The only bank that they had any sort of a relationship, and I'm not even sure what that was, whether it was Enlightening or one of the board members or whomever, was with Bank of America. And Bank of America would not do an unsecured line of credit. So their terms were that all of the existing shareholders in Lightning provide personal guarantees for the line of credit. That was turned out to be not something that was palatable to the shareholders, the other shareholders. And so you're now faced with one of two possibilities: default on the line of credit, which, would essentially crater the company immediately, or somebody needs to step in. So I didn't really want to, but I stepped in and assumed the line of credit, and it basically under the same terms as had been with Home Valley Bank. It wasn't like we wrote up a new agreement with different terms or whatever. It's like, okay, I'll just assume the line of credit under the existing terms and conditions.
So would it be fair to say you stepped into the shoes of the bank?
Yeah, that'd be fair to say. I became the bank of Scholler.
When you assumed the line of credit in June 2002, did you receive any shares of the company?
No.
Did you include this line of credit that you stepped in the shoes of the bank, or did you include that in the calculation for the bad debt deduction?
I believe so, yeah.
Okay. Let's see. I believe at one point, well, I'll return to that. I want to move to the loans at issue. Do you have Exhibit 1 there? Appellant's Exhibit 1?
Do I?
Yeah, I don't know if I can. I don't think I can bring it up through the
Okay,
phone.
no, I have things on my tablet here if I can.
Yeah. Okay.
What Exhibit 1? Okay, yeah.
Okay. I have this labeled as a reconstruction of loans from you to NSDI. The first payment is dated June 4th, 2001. Is that correct?
Yes.
What happened in June 2001?
The company's sales were not ramping up as quickly as they had hoped. The initial positioning or the initial thrust for their marketing and sales was through Christian bookstores, Christian retailers, and as reported to me, to the other rest of the members of the board, in Ralph Bagley and Dave Caputo's estimate, it was simply a matter of retailer education. This was something new to them, and they basically had a hard time in knowing how to market and sell it to retail customers. But they were taking steps to remedy that. However, what that meant was you had two things going on. One was the cash flow needs of the company based on their burn rate, And also there were compliance terms and conditions related to the line of credit with Home Valley Bank that needed to be maintained. I don't remember exactly what those were, but you know, it involved how much, maintaining certain balances in their accounts, etc. So they were, essentially needed additional cash. And so I agreed to provide them. This was believed to be, a short-term hump that they needed to get over. And I agreed to provide a series of short-term loans as needed to, assure that their terms and conditions with Home Valley Bank were met and their cash flow needs for continuing operations were met.
Was there a meeting or a call where these new loans were discussed, or could you give us some more information about that meeting, if there was one?
Sure. There was a board meeting. For me, it was telephonic because they're in Medford, Oregon, and I was in California. At which time my offer of providing short-term loans was discussed. It was a real simple agreement that was reviewed with the board of directors and approved by them. Of course, I had to bow out of that portion of the discussion for obvious reasons. Anyway, but yeah, it was they approved my providing short-term loans to the company.
Okay. Do you know who else was on the call where this was discussed in the board meeting?
I believe Doug Dietrich was in the office with them, although he may have been on the phone. That's a better question for Doug. I don't recall. I believe all of the board members were there, which would have included Cleta Charles. Fortunately, she passed away some years ago, so it's hard to ask her. So yeah.
Was Ralph Bagley was on the call?
Oh shit. Yeah. I mean, Ralph chaired the meeting. So
yeah. Okay. What were the terms of the loans? You said they were short term, but was there a repayment schedule and interest rate?
Yeah, obviously, if you're running short of cash, the interest would be accrued, and then when the company's revenues or cash in exceeded their burn rate, that the loans would be repaid on a first in, first out basis. So whatever, in this case, the June loan would be repaid first with the accrued interest, and then so on until it was fully repaid.
Was there a written loan agreement for these short-term loans?
Yes.
And was it signed by the parties?
I believe so. I wasn't in the room, but yes.
Was it signed by you?
I believe so. I think the sequence was after they signed it, it was sent back to me, um, you know, to be signed, but not as a board member, to be signed as the lender.
Do you recall if it was mailed to you or faxed to you?
Not specifically, but most other things that of that nature were mailed to me. So I'm guessing it was probably mailed.
Okay. I'd like to turn to these short-term loans, still talking about them, how it was that you made these loan payments or these loan disbursements to NSDI.
Okay. Yeah, so the author,
Could you, yeah, go ahead. If you could explain, yeah.
The implementing logistics of it were that it would have the requests would have to be approved by Ralph Bagley. Sometimes I would get the request from Michael Acton, but that was always followed up with an email or a phone call with Ralph to confirm, because that was the deal. My requests were ACO Asset Management provided the umbrella financial management for me, or yeah. And so the requests primarily, not entirely, I also had accounts with Silicon Valley Bank. So in either case, it would be, I would send them a fax with the wiring instructions for the amount to be dispersed to Enlightening. On the other side, Enlightening put them on their books as a loan increment. They kept track of them, and then periodically, usually like once a month, would compare notes. Here's what we received, here's what I authorized, just to make sure that the two matched up. We wanted to keep it simple. At the time, I was in the middle of, I was hired as the 11th employee at Interlays. 2 years later, we had 100 and some employees. We were, I had to build an FDA approved manufacturing facility, get FDA compliance. I was working 14 to 16 hours a day, 6 to 7 days a week. I only provide that not for sympathy, but simply I had to keep it simple, and
could we return to the wire transfers?
Yeah.
Wire instructions, great. The exhibit 5. Do you mind pulling that up? And it's labeled. If you're looking at the OTA exhibit, it's page 9 of 100. Exhibit 5. If you're looking at Bates stamp that I put on it, it's page 8 of 99.
All right, let me see what it says here. I don't think it says either one of those things.
It'll be in the bottom middle where it's the page number.
I'm looking at the file I have up is otaca-mysharepoint.com.
Yeah.
And what I'm
it would be page.
This shows
go to page
322
89 on the PDF. Go
Which
to page
one?
89 on, yeah, that's right. Page 89.
Okay, hang on, let me go. It's a tablet, so it's a.
This is Judge Basig. While you're looking that up, I do want to mention that because we lost about 6 minutes of appellant's time, I did add to the end of your time, Mr. Colabianchi. So you have until 12:45 to present the witness testimony. And just a reminder that for some of your witnesses, we do have submitted declarations. So if you would like to avoid having them repeat that, you can just let us know there's a submitted declaration, and we can allow for any additional information and for questions from Franchise Tax Board and the panel.
Understood. Thank you.
Okay, yeah, I'm on.
Just a moment. I see we have a question from Mr. Cotino.
Yes, sorry, just to clarify, Judge Basig, were you talking about the entire witness testimony would be till 12:45, correct?
Yes, for all witnesses.
Okay, thank you very much.
Okay, Scott, are you able to get to that exhibit?
Yes, I am.
Okay, so we're on page 89 of the OTA exhibit. What is this document here?
It's a wiring instructions from me to Emily Clayton at MSDW.
And how much was it for?
$21,000.
And what was the date that these instructions were sent?
August 27th of 2001.
All right, and then could you go to the previous page, please? Should be
yeah, it's a bank
page
statement.
8 of 100. Yeah, and what is this document? Whose bank statement?
Pardon me? It's enlightening.
Who's okay?
It's enlightening software's bank statement.
Great. And can you see kind of midway down the page, is there a deposit?
Yeah, there's a deposit on 8/28 of 2001 from an incoming wire of $21,000.
Does this exhibit, sample of this exhibit, does it generally capture the payments made to NSDI under this short-term loan agreement?
Yes.
Okay. At this time, how were NSDI's sales progressing at this time when you began giving short-term loans? How were the sales progressing, and what do you recall about their financial situation?
Well, they were, they still weren't at cash break even, so that necessitated the short-term loans, but that's funny.
What were the prospects for the sales of their software?
They were starting to trend upward. Second.
I'm going to take this moment to remind you that if you're overlapping each other in discussion, we lose something because Ms. Moss can only transcribe one part of the conversation. So let's be careful not to overlap.
That wasn't me. That was Chat GPT on my tablet chiming in. Okay. What was the question again? I'm sorry.
At this time, when you started making the short-term loans to NSDI, how were software sales, and what were the prospects for the second title?
Well, the sales of catechumen, going back to the previous was I mean, this is only a couple of months later. They're still working on retailer education, and we're taking some steps to provide better or improved tools, like displays that you could use like at an end cap at in a store. But a lot of it was they just had to spend time with the retailers. Their intent was, again, you're a new genre. The Christian video games or faith-based games were not a genre of video games, just as if you went back into the 50s, Christian music wasn't a genre in the music industry. So, there's a lot there was a fair amount of work to be done. So the sales were still low, but growing and encouraging.
Did you receive anything for these short-term loans other than interest, promise to pay interest and repayment?
No.
Did you receive any repayments for these loans?
Not in that, obviously not in that time frame, but I may have in early 2003. I don't, if it was minimal. I just don't recall.
But most of the funds you sent as loans to NSDI under these short-term loans were not repaid. Is that correct?
Correct.
Okay.
Yeah, let me
What were the
clarify. If I received anything, it was probably related to the line of credit, but yeah, I just don't remember.
Okay. Okay. I want to pivot a little bit now. As you know, one of the requirements for the bad debt deduction is that it's taken in the year when the debt becomes worthless.
Mm-hmm.
My next question will have to do with the closure of NSDI's operations. So you just testified that on the whole, NSDI did not repay you for these short-term loans. Why did they not repay you?
They didn't have the money.
When did you realize that they would not be able to repay you?
The wheels started coming off in early 2003, when they discovered that they had been embezzled to the tune of something over $115,000, which translated to 1/4's operating expenses. That coupled with the year of 2003 was kind of a make or break year for the company. Prior to that, the focus had been on Christian retailers, and then in 2001 they shifted to youth groups and the like. Something that Ralph can talk to later, I guess. Yeah, because so the forecast, the projections from fall of 2002 for the year 2003, showed the company selling something around 250,000 games. That's a big number, but not big when in retail distribution. They had done some pilot work with some major retailers, Target and GameStop were two that I remember. There may be more. Again, that's a better question for Ralph Magley. But it was their projections, their forecast was heavily dependent upon being able to get into the large retail distribution channels. The combination of all of a sudden you realize that you're $115,000 or so lighter than you thought you were, and you have records that have been destroyed, both physical and digital, police reports, all of that sort of thing, plus the impact on being able to get in front of those retail distributors, ended up, and there were a few other things of the kinds of demands the major companies, like specifically Walmart being one of them. And I don't know all of the specifics. Ralph can probably talk to that as well. But the end result was they were not going to be in any meaningful way distributing through the likes of GameStop, Walmart, and or Target for the holiday season of 2003. That was the games at this point. Catechumen was released in 2000. Ominous Horizons in 2001. Games have a relatively short lifespan. Technology changes and so on. So a 3 or 4-year-old game is not a seller. So if it got into retail distribution in the US in 2003, that opens up the doors to international sales, Korea, Europe, South Korea, Europe, so on. It's not true anymore, but at that time, that's the way most games traveled. Didn't include Japan because they developed many of their own games, but games developed in the US, if there was success in the US, then they could be successful in other markets. So when all of that is missed, you're not going to get another shot next year. It's if you had a new title, there's kind of that drafting effect, which you see in many of the video game franchises, where if you come out with game X version 10, well, that means 9, 8, 7, 6, 5, 4, and previous ones will have a continued lifespan. But if you don't, you don't. So by things were looking pretty severe by June. The company attempted to try to shore things up, but by August it was clear, despite their best efforts, the company was going to fail.
Scott, I'd like to turn to Exhibit 2. It's page 7 on the OTA exhibit
Page.
on the PDF document. Page 7 in the PDF. Just let me know when you have it.
Scrolling as fast as I can. Yes. I am it.
Okay, and this is a letter, it appears to be to you from Ralph Bagley, dated September 22nd, 2003. Are you familiar with this?
Yes, I am.
In this letter, Ralph Bagley states that you loaned NSDI more than 1.9 million. Is that correct?
Correct.
Now, would that include several lending events, correct? The first
Yeah, that would be
lending
the
event.
combination of all of them. The original
Okay.
and then the line of credit and then the short-term notes.
Okay. And he also states in the letter that he had been forced to eliminate NSDI's entire staff. Is that your recollection of
Correct.
events? And that he would also be unable to repay the loans you had made to NSDI. Is that right?
Correct.
Now, when you received this letter, did you believe your loans to be worthless?
Yeah. Unfortunately,
To your
yes.
knowledge, okay. To your knowledge, did NSDI ever conduct business or pay employees after 2003?
Did not pay him. Did not have any employees and did not pay anybody after 2003.
Okay.
I can talk probably later, but I made the decision as, kind of the last person standing to not file, to not drive the company into bankruptcy, but rather to retain it as a shell. And I asked Ralph Bagley to retain the title of CEO, even though he was not an employee and was not going to be paid, for the simple reason that the company had built up a certain reputation, and he was the face of the company. He was the only person that the outside world knew that represented Enlightening. Also, the company had about 100 and some odd thousand customers out there. Ralph Bagley and Chris Perkins volunteered to continue to provide technical support to customers for a period of time. I don't remember how long that went on. It was quite some time, without pay, simply because it was the right thing to do in not having the customers who had bought games to be shortchanged on support.
Did you discuss this letter with anyone else?
Did I discuss, pardon me?
This letter, Exhibit 2, the one we were just looking at, did you discuss it with anyone else?
Sure. With Richard Berry, who is the financial planner, did our taxes from ACO Asset Management.
And what did he suggest? What action did he suggest regarding this letter?
His first question was, is there any chance these loans are going to be repaid? And I said, no. You know, as evidenced or as stated in the letter. And then, you know, this is not something that I knew. And he said that you have to take bad debt reductions in the year that you but that know that it's a loss. You can't defer them, carry them over, or anything like that. So bad debt reduction or bad debt write-off would have 2003.
Did anyone else talk to Richard Berry with you about this?
Yeah. This was part of he would every year, you know, at about that time, September or thereabouts, he would meet with my wife and I at our home and go over the tax preparation requirements for that year, and then start talking about planning for the succeeding year.
Do you believe he was a competent professional?
Yeah. That we came to be use Richard was the compensation committee of the board of directors at Cymer interviewed a number of firms and selected ACO Asset Management to provide financial planning and tax services to the executives at the company as part of our compensation package. So, and in specific, then once they had selected ACO, then Richard Berry was selected. So he not only was taking care of my financial planning and tax needs, he was all of the other executives at Applied Materials, at Cymer as well.
And did you provide everything he asked you to provide in order to draft the return?
I did.
And did you rely in good faith on his judgment, what you should do with this letter and how you should treat it on your taxes?
Yes.
And when did you ultimately claim the bad debt deduction? What year?
2003.
Or which tax year?
2003.
And let's see, were you subsequently audited by the IRS?
Yes.
What happened during that audit?
Well, it first started that they just said, "Hey, we have some questions," and it was several years later. I don't recall exactly what the time frame. But then they followed up and asked for a bunch of documentation, which we provided. And then it was, I had provided ACO or a power of attorney. So the interaction was going between them and the IRS office. But they would update me with phone calls and whatever emails that they were leaving messages and not being able to get anything back from the person had was reviewing the information, that person had sent a letter that said, okay, here's how it goes. I'm going to ask for some documentation. After I review it, I may ask for more documentation, and then we'll sit, we'll have a face-to-face meeting. Well, that never happened, ever. There were never a meeting between either ACO or me or anybody else directly with anyone at the IRS. On about the anniversary, I don't know if it was the first or second anniversary of their initial request. We were informed that the person was no longer at the IRS. A new person was assigned, and I have no idea how long they had that they looked at what had been provided, but they declined it and passed it off to someone else for further review. That led to a sequence, that is kind of hard to understand, but it passed through maybe 4 or 5 different offices and a greater number of individuals. Some of the things were that I saw in correspondence back from ACO to the various individuals as they'd ask for information that had already been provided, or say that things had not been responded to when they had. At the end, we asked for the documentation back from the IRS, when they had finished. And what they sent back was a small fraction of what had been provided to them. So I'm not sure, exactly what went on. While during the course of this, I was advised by ACO that there's 2 routes you can take. One is an administrative review route, and the other is, a legal route. And they said, this is a simple matter. We have a pretty good relationship with the IRS. This should be easily resolved. We don't recommend, they said, I want to be concise. He said, it's ultimately up to you, but our suggestion is you don't need to go the legal route. This can be resolved administratively and it'll be fine.
So to clarify, did you ever file a U.S. tax court petition?
A what?
A U.S. tax court petition?
No.
And was this upon the advice of your tax planner, your tax preparer? Yeah. Okay. Okay. I have no further questions this time. Unless Scott, you'd have anything you'd like to add?
No, I think we've basically covered it. Judges, do you have any questions?
Thank you, Mr. Scholler, and thank you, Mr. Colabianchi. I'd like to check with my panel members if they do have questions, and Mr. Coutinho might have questions. I'd like to see first if we have questions. If not, we'll take a break right now. If we do have questions, we'll see. Maybe we'll take a question or 2. So, Mr. Coutinho, do you have any questions for this witness?
This is Brad Coutinho for respondent. No questions at this time. Thank you.
Thank you, Mr. Coutinho. Judge Aiken, do you have any questions for Mr. Scholler?
I do have one question and I can try to keep it brief. But I'm fine with taking a break first if that's your preference.
Okay, let me check with Judge Clutter. Judge Clutter, do you have any questions?
I also just have one brief question, so I'm happy to ask it before the break or after.
Okay, so let's do the questions now since they're brief. I'll go back to Judge Aiken. Please go ahead.
Sure. Okay, Judge Aiken speaking. Since we don't have the promissory note in the record, I just wanted to verify one potential term. It's regarding the interest. And if I recall your testimony correctly, you said that the interest was to be accrued and then paid along with the loan once, the company started bringing in sufficient revenue, is my understanding of your testimony. So did the promissory note, did the term provide for that interest to be accrued, or did it provide for, periodic payments of the interest, maybe monthly or annually, to the
No,
best of
it
your
was to be, yeah, it was to be accrued. So when you paid off one of the increments, it was to be done FIFO, first in, first out. So in this case, the August one would be whenever they paid it, it'd be the accrual up to that point in time, plus the principal would be paid. Okay, and then you move on to the next one. Right.
Understood, and that answers my question. That was all I had. Thank you.
Thank you, Judge Aiken. And now we'll go to Judge Clutter.
Yes, this is Josh Clutter. I just have a question about, I guess, to recap my understanding, you mentioned that when the January 2000 loan was, that original 400 and 450,000, that was at a fairly high interest rate to the company. And then the 2001 loan, and also the line of credit, those were at a lower interest rate. And I was just wondering if you could explain why those loans were at such a low interest rate, and particularly for the Home Valley Bank, you had mentioned that there were some interest rate reductions over the course of that line of credit, but you just stepped in the shoes at that lower interest rate. So just wondering.
So the interest rate on the line of credit was what Home Valley Bank was charging. Right. So they were, if you recall, during that time frame, interest rates were dropping like a stone. I don't remember where they started at, then, like 9% or something, and 15 months later they're like 2. So the original was at a fairly high rate, simply because when the original loans were made, the company said they were going to be able to bring out a product in 9 months. I was a little bit incredulous, because that seemed like a pretty aggressive scale, time frame. So they had no track record, no product, no sales. So it's riskier, right? By the time that I agreed to make short-term loans, interest rates were dropping. That's one thing. The company had met its schedule. It got its games out on time. They were well received. They didn't have a lot of bugs in them, and they were being reviewed well, even by what you might call secular reviewers. So in any sort of startup, the debt financing is a negotiation of what's fair to both parties. And certainly, while It wasn't as high interest rate as either the Home Valley Bank thing. It was more than I was going to make on a being in a savings account. So it seemed fair to me, and it seemed fair to them. So does that answer your question?
This is Judge Clutter. So that does answer my question. I do not have any further questions. Thank you.
Okay, everyone, I'm going to ask you to mute your microphones and turn off your video. My understanding is that the live stream continues while we are on break. We will be taking a 10-minute recess and going off the record. Mr. Lopez from OTA might be checking in with some of the new witnesses at this time, so please hold on for a moment while he does that, and then we will resume at 11:55. Okay, hello everyone. We are ready to return from recess. So I'm going to check in with the parties and my panel to make sure we're all here. Let's go ahead and get back on the record. And I see that Judge Clutter and Judge Aiken are here. Welcome back. Mr. Cotino, welcome back.
Good
And
to see.
yes, sir.
Sorry, I just had a quick question just in regards to the timing of the hearing. I know earlier you stated that appellant's witness testimony would go to 12:45, and then obviously respondent would have its argument, and then there'd be appellant's rebuttal. Is that still the time frame?
I'm going to add a 10 minutes to account for the break we just took. So appellants have until 12:55, and I realize they have 7 witnesses, so they'll have to be very efficient
Okay,
with
thank you.
their
I really
time.
appreciate that.
And then we will move to you for your 15-minute presentation, and appellants will be given an opportunity to present a rebuttal of 5 minutes. I see that Miss Mosk is with us, and I just want to make sure we have Mr. Colabianchi. Mr. Colabianchi, since you are on a phone and I can't see you, can you just let me know you're here?
Hi, Your Honor. Yes, I'm here.
Right. Thank you for that pause. I actually was going to mention that. It seems like we did have some overlap in the transcription efforts. It makes it a little difficult. So we're going to try with the next witnesses. I want to remind everyone to please just give a tiny pause after a question has been asked and then go ahead and answer the question. Okay. We are ready, Mr. Colabianchi, for the next witness. Who will you be calling?
Your Honor, I'd like to call Gay Scholler.
Okay, and Ms. Scholler has been sworn in and she is under oath, so please proceed when you're ready.
Hi, Gay. Good morning. Well, good afternoon, where you are, I believe. How long have you and Scott been married?
For 44 years. We're old.
And Scott testified about enlightening. And when did you first hear about enlightening, whether from Scott or otherwise?
It was from Scott. I heard about enlightening in the year 2000 when he said he wanted to give them a loan for approximately $850,000.
And did he, after that, when he spoke to you about it, did the two of you discuss whether you should loan, and was there a decision made?
Yeah, we decided together to do the loan. I said, yeah.
And this was in 2000, is that right? Sorry.
Yes, it was.
Okay. And after that time, did you discuss loans from you and Scott to NSDI at any other point?
I'm sure we did. I don't remember the specifics on all that. He kind of took care of that. And so if he did anything and ran it by me, I probably said yeah. So that's all I have on that. I don't know.
What happened?
I'm sorry.
What happened to those loans?
The loans that he made to them?
Correct.
We didn't get paid when the company was closed. Is that what you mean?
And yes. And do you recall how much those loans were for at the end?
No, it was quite a lot. It was over $1 million.
So it was more than the $850,000 that was initially lent. Is that correct?
Yes, it was.
Okay. And then did you and Scott, well, Scott testified that these loans were discussed with Richard Barry, your tax preparer. Is that correct?
Yes, that is. He came to our house every year, and we do an initial tax preparation thing. And the year that it closed, Richard told us that we needed to take a loss off the taxes of the year that it closed, which was 2003.
Okay. Okay. No further questions. Thank you.
Thank you.
Thank you. Mr. Kolobianki, who will you be calling next?
Mr. Ralph Bagley.
Okay. Would like to double check. I believe Mr. Ralph Bagley was in the first batch of witnesses that were sworn in. Is that correct, Mr. Bagley?
Yes, I'm here. And I was
Okay.
sworn.
You were sworn in. Great. Just a reminder that you remain under oath until the end of this hearing. I do want to go back to Ms. Scholler. Sorry, I wanted to make sure and see if Mr. Coutinho has any questions for Ms. Scholler.
This is Mr. Coutinho. No further questions. Thank you.
Okay. Judge Clutter, did you have any questions for Ms. Scholler?
No, I don't have any questions.
Thank you. And Judge Aiken, did you have any questions for Ms. Scholler?
No questions. Thank you.
Okay, thank you. Mr. Kolobianki, you can proceed.
Hi, Ralph. Good afternoon. So let's see. Scott testified that you were the founder and CEO of Enlightening Software Development, Inc. Is that correct?
Mr. Bagley, you can unmute yourself by pressing *6.
Sorry about that. Yes.
That was correct?
Yes.
Great. Okay. Can you describe how, why, and when NSDI was founded?
Well, back in 1998, actually, I began work on, I took some theology classes and began work on a game design, a very raw one, to provide a healthy alternative to the games that were coming out at the time, Doom, Grand Theft Auto, these real violent games, as an alternative, a high quality alternative for people to play that, you know, wasn't just all death and destruction and satanic imagery. And so once I got that done, I found some people here in the Valley that I had had previous relationships with. A couple of them were from my church, to go ahead and lend me the money to get a demo done. It's called a vertical slice in the gaming industry. It's just a very short piece of gameplay with graphics and audio and scripted gameplay that you can show people that this is what the quality of the game is going to be. And so we did that. And then at that point, we had the tools we needed to go out and seek, financing for the company to actually be a company, which was considerably more, around $900,000. And so I got in my car. I had some appointments with some VC firms and went down to Menlo Park in the Bay Area and talked to some VC people. They quickly advised me that, equity financing was not the way to go, that debt financing was really the only option I had, because we didn't really have a company at that point. We just had an idea. And so I came back, took a couple of weeks with my team to create basically a presentation, and then went out and started talking to VC people again. And, they recommended probably angel investors would be the best way to go. And so I began asking people, especially in the VC companies, do you know anybody? And that's how I actually met Scott, was through a gentleman, I believe his name was Russ Hall. And they had been friends previously. And so he connected me with Scott, and I was able to meet with Scott and show him what we were doing. And then not too far past that, Scott called me and said, hey, I think we can go ahead and do the loan for you. So.
Okay. And so you said Scott offered a loan for it. What were the terms of that initial loan?
I believe it was around $850,000. I don't have the exact number in my head because I'm just going by memory here.
Yeah.
And it was to be done in two segments. The first segment was, I believe, $400,000, and then the second was $430,000, which was fine because we weren't going to spend the whole 850 right off the bat. That was in the business plan to get us in development and then get us out to the marketplace.
Okay. Let's see. Scott has testified that NSDI established an unsecured line of credit with Home Valley Bank in September 2000. Is that your recollection as well?
Yeah. It's a good idea for really any business to have a line of credit in case something happens or you get an opportunity that you need to pivot and move quickly. So yeah, we secured, I think it was a $400,000 credit line through Home Valley Bank.
And what happened to this line of credit?
Well, I mean, we were using it, and then I think, in fact, at one point they renewed it. I don't recall exactly when. And then after the renewal of the loan, Home Valley Bank got bought out by another bank called Banner Bank, and Banner didn't issue credit lines. And so they notified us with very short notice and said, hey, this loan we're going to close it down. And so I went into scramble mode, and I believe we tried meeting with some other banks, and it would have been months to get that thing approved. And so, I went to Scott and I said, hey, this is the crunch we're in. If we don't have this line of credit, it's going to be really hard, especially to grow in the marketplace, because, we were using that for inventory and marketing and things like that. And Scott basically went ahead and just took over the credit line. So instead of dealing with Home Valley Bank, we had a credit line with Scott.
Would it be fair to say that Scott stepped into the shoes of the bank?
Yeah, that would probably be the best way to say it, actually.
Okay. Let's see. Scott has testified that in 2001, NSDI obtained commitment from him to provide a series of short-term loans in addition to the already $850,000 he had loaned. So this is 2001. Is that correct?
Yes.
And this 2001. Was this before he stepped in the shoes of Home Valley Bank?
Boy, I think we had that, the unsecured line of credit with Home Valley Bank, I believe was in fall of 2000 that we initially established it. Now, I'm trying to just remember real quick here. I think they renewed the line of credit, Home Valley Bank did, the following year, fall of 2001. And then shortly,
And what? Sorry, go
and
ahead.
then shortly thereafter, like spring of 2002, is when they told us that they wouldn't renew it, because I remember it was like June that was the deadline. And you know, I think they
Okay.
notified us in May.
Going back to these short-term loans that began in 2001 from Scott, what were the circumstances surrounding these loans, and why did NSDI need them?
Well, we had our sales were actually improving, and we had created Catechumen and Ominous Horizons, and we were really needing to launch these things into the marketplace. Well, there was a lot of expenses that we didn't realize that we would have to do to get into some of the major retailers. We had talked with Target and GameStop, and they had agreed to carry our products, but of course they needed, marketing materials, in-cap materials. Obviously they needed a certain level of inventory available, and we had to, back then, games were on the shelf, and so we had to, purchase the boxes and the wrapping and the discs and all that stuff. So we needed cash, and so that's why I approached them.
Okay. And was there a board meeting or anything similar that discussed the short-term loans that NSDI would be procuring from Scott?
Oh yeah, we had board meetings basically for every major decision.
And were there board meeting minutes that were produced?
Yes, there were.
From that meeting?
From every meeting, there were board minutes produced.
And what do you think happened to those minutes?
Well, I know exactly what happened to them. A few years later, after the business had closed and we had a lot of this stuff just in storage, the records were on a pallet in the warehouse underneath a skylight. Well, we had a massive snowstorm. I mean, it's probably the biggest snowstorm I've ever had since I've been here, and I've been in the valley for, over 20 years. And this skylight in the warehouse collapsed in, and ruined, I think it was 6 pallets of stuff. And one of the pallets that it ruined had our records on there, because it was all paper records. And, it was buried in a massive pile of snow that then melted on top of them. And all of those papers were basically mush. And they were already several years old. And so, I thought that there was a 7-year statute of limitations. And so at that point, I wrote it off. I mean, said, well, these are not salvageable, and we tossed them.
You recall the terms of the short-term loans that with Scott?
Oh, I mean, I don't recall the exact terms. It's been over 20 years, but I know, the basic terms were, when we received the loans, that our sales would increase. We had a plan to do that, to increase sales in 2003, that was going really well, until, we found out we had been embezzled. And at that point, everything kind of caved in, and we weren't able to to meet sales that we had hoped. And a lot of it too, I remember, we had to pivot from the youth groups, which was a big deal with us. And I remember in September 11th, 2001, I was in the airport in Portland, actually in the airport when the first plane hit that tower in New York. And I was flying out that day to meet with 600 youth pastors at a convention that Youth for Christ had organized. Well, obviously, they shut the airport down. The conference ended up getting canceled because nobody could fly to it. And that was a major wound in our marketing program because we had to go back and redo everything and try to, and we had missed the window. And so it put a real onerous position for us as we went in, 2002 was a year where we didn't achieve our sales goals because we had to, pivot and kind of react to what happened with 911.
Mr. Bagley, do you have the proposed exhibits that I submitted? It would be Exhibit 17. I believe I sent them in an email to you.
I do.
Okay. Could you please turn to Exhibit 17? It's Statement of Financial Position.
Yep. Hold on here. And it's page what?
In the PDF I sent you, it would be page 33.
Hold on. Bear with me. Sorry, guys.
No problem.
Okay, I got it.
Great. And what is this document? It says Enlightening Software Development, Inc., Statement of Financial Position. What is it?
That's actually not the one I brought up. Hold on. Okay, I got it. It is a P&L and a balance sheet that was created that details out, what the liabilities and assets we had at the time.
What was the context for the creation of this document? Was it attached to another document?
No. I actually found this when I was looking for our official release date. It was on a sound asset folder that it shouldn't have been in. And so when I found it, I went, oh, and so this was something that I just recently discovered.
Okay. And to clarify, is this a printout of an Excel file that you found?
Yes.
Okay. Let's go to line 28. It says long-term debt.
Yes.
It says below, or on line 28, it says notes payable stockholder. It is 1.5 million. Do you know what that number represents?
That's the loan amounts that he had given us up to that point. Yes.
When you say he, that you're talking about Scott Scholler?
Yes. Yes. Sorry.
And then if you go above a little bit, there's line 22. It says accrued interest stockholder. Yep. Is that related to that note payable?
Oh yeah. Yeah. No. In the
agreement. And then below that. Okay. Sorry about that.
In the agreement. And then he had. We had agreed to pay interest and give him shares in the company too.
Okay. And then below that, there you have line of credit refinanced by stockholder. Is that the Home Valley Bank line of credit?
Yes, it is.
And then there's also interest on that refinance. Is that correct? Below that?
Yes.
Okay. I'd like to talk now about the end of life of NSDI.
Okay.
So Scott has testified that he wasn't repaid, or if he was repaid, it was a very small amount for these loans. Well, Scott mentioned Michael Acton. How did his actions affect the business?
This guy. He was hired as our CFO, and he had, had all the credentials. We went ahead and hired him, and he was a piece of work. He would come in and pray with us in the morning, and then go in and figure out ways to steal from us. And I didn't realize what was happening until 2003. Our sales were actually growing, but we had no money in the account, and I was like perplexed. And so I took a weekend and just went through all of the documentation I had. And then that Monday morning, I remember I went to the bank and asked for printouts of all the checks. And that's where I caught him. Is what he was doing was showing myself and the board fake, well, like quarterly tax returns, right? He would inflate the number to us and then write himself a check for the difference. And sometimes he wouldn't even pay the IRS. He would just keep the whole amount. And so when I caught him, obviously I went to the police immediately after I documented all the checks that he had basically forged. And they charged him with embezzlement. I think it was 115,000 initially, but dropped down to 102 because there was a few $1,000s that we couldn't prove.
Did his embezzlement have a direct effect on NSDI's closure?
Oh man, it was catastrophic. It was almost a full quarter of money that we needed that was now gone and missing. And so, that really hurt us. And then on top of that, all of the work that I was doing, to market the games and get them out there, I had to stop and deal with this legal thing because, I had to go through the whole set of books since Michael Acton had been there and identify each and every instance and then talk with the police about it. I mean, it was catastrophic.
Scott Scholler has testified that NSDI closed down not long after that and had to let go its employees. Is that correct?
Yes, unfortunately.
And do you recall what year that was?
It would have been 2003. I think late summer, early fall, somewhere in there.
Okay. Could you please turn to, these would be the previous, not the proposed exhibits, the main exhibits on OTA's file. Let me see. It was, I think, page 34 of 68 for exhibit 4.
Okay, I'm trying to pull it up right now. $34.
Yeah, 34 of 69, excuse me. And it would be the blue bait stamped pages on the bottom of the page.
Oh boy.
If you have the whole PDF, it would be page 45.
Okay. Yeah. And this is the hearing binder and exhibits?
Yes. Yeah.
Sorry.
Actually, if you could go to page 46, please, on the PDF
Got it.
file.
I'm here.
Great. So this is an account transcript from the IRS.
Yes.
And this, let's see. Are you familiar with, I guess, payroll taxes? Are you familiar with the payroll taxes that were part of compliance with
Yes.
tax law?
Yes.
And what this, it says tax period June 30th, 2003, and it says there was a tax return filed September 1st, 2003. Is that generally comport with your recollection?
Yes, it does.
And it also says that there was $9,600 worth of payroll tax paid for this period. It would have been April, May, oh, excuse me. Yeah, it would have been April, May, June period. So that implies there were employees in that quarter. Is that correct?
Yes.
Okay, and let's go to the next page, please. It would be, let's see, page 36 of 69.
Okay.
And this is the same account transcript from the IRS, Form 941, the tax period ending September 30th, 2003. That would include July, August, September. Was a tax return filed?
No, because that's when everybody basically was laid off.
Could you go to the next page, please?
Okay.
And there is, let's see, this is for the fourth quarter of 2003. There was also no tax return filed.
Yes.
Do you remember it that way?
Yep.
So for the rest of this exhibit, there are no tax returns filed. In fact, it says requested data not found, and this goes to the end of 2009. Did NSDI ever have payroll after 2003?
No.
Okay. Let's see. Okay. Exhibit 2, please. This would be page 6 in that same PDF.
Okay.
Actually, page 7. This is a letter from you to Scott.
Yes.
Do you recognize this document?
Oh yeah, this was a very painful one for me to write.
Okay. You stated that Scott Scholler had loaned NSDI more than $1.9 million. Is that correct?
Yes.
And that NSDI would be unable to repay Scott. Is that correct?
Yep. At that time, that it was quite clear.
Why didn't the business file for bankruptcy?
Well, when I first started this, part of the reason that Scott was a very attractive option for us was he understood that this wasn't just about making money. We wanted to provide a high quality, faith-based alternative out in the marketplace. And we did that. These games they still have really good reviews from people that play them, even though they're over 20 years old now, and we wanted to set an example. There's so many so-called Christian businesses that, they don't operate as a Christian business. They say they are, but they don't. And so we didn't want to be that. And Scott is one of the guys that I've known in my life now that has integrity. And so we both agreed that we would do whatever it took if we could to pay off anybody that we owed and not stiff them. And so that was the whole reason that, we wanted to make sure we paid everybody off so they couldn't say that we were hypocrites.
Could Scott have initiated an action to recover the loans or to attempt to recover the loans?
I don't see how. We had no assets. I mean,
Okay.
There was nothing we could do.
So would you say that if he had done something like that, it would have been futile?
Yeah. I mean, we had no money.
Okay. All right. No further questions.
Thank you for your testimony, Mr. Bigley. I'm asking you to stay with us while we go to Mr. Cotino to see if he has any questions.
And I apologize about my camera not working, but at least the microphone works.
That's the important part.
This is Brad Catino. No questions.
Thank you. I'd like to ask Judge Aiken, do you have any questions for Mr. Bagley?
Thank you. Yes, I do have one question. Mr. Bagley, you testified that all of the employees were laid off, summer of 2003. Can you describe what, if any, operations the company had after that, in 2003 and in after June, and then in any subsequent years?
Well, I mean, the only operations we actually had was just tech support for our customers. We had close to 100,000 games out there that people had purchased, and I didn't want them, to be out there with no support. And so I volunteered along with Chris Perkins to take care of that tech support, by phone or email when we could. And we did. I think it went on for several years after that.
Okay, thank you. And just one follow-up question. Was there any continued sales of products, after approximately June 2003, and in subsequent tax years, or any continued development of new games after that?
There was no continued development of new games. We did try to contract out with some people that might hire us, but none of it panned out. And then as far as sales, it had gone down to a trickle. We did have a few units in the warehouse that we ended up donating to Campus Crusade for Christ and some other organizations. So the answer really is no. That if it was very, very minimal. Just and anything we did get, we paid off our vendors with.
Okay, thank you. That's all of my questions.
And I have no questions, so we are almost ready to move on to the next witness. I do want to note that we will be factoring in question and answer time in determining appellant's remaining time allotment. Mr. Colabianchi, you don't have a lot of time and you have several witnesses on the list, so who will you be calling next?
Your Honor, could you remind me when is my time over at this point?
Yeah, your time would be over 12:55. I'm going to add another 3 minutes to that for the question and answer portion we just did, so 12:58.
Okay, well, I would like to call Dave Caputo, please.
Mr. Caputo has not yet joined the meeting.
Okay, if Chris Perkins is here, then I could call him.
Oh, I'm hearing that Mr. Caputo has joined. Let's give it just a second and see. Waiting for confirmation from our team. They meant that Mr. Perkins is in. Okay. Mr. Perkins, you have been sworn in already. So Mr. Colabianchi, proceed when you're ready.
Hi, Mr. Perkins. So let's see. Ralph Bagley testified that you were the project lead at NSDI. Is that correct?
Mr. Perkins, go ahead and press *6 to unmute yourself.
I'm sorry, I thought I had already pressed that. My apologies. Yes, that is correct. I was the project lead at Enlightening.
And briefly, what does that mean?
Well, I was in charge of the programmers, the artists, and the sound people, just making sure we have a cohesive product and delivering it on time.
So do you have a copy of your declaration, or are you familiar with it? It would be
familiar with it.
Exhibit 10. Okay,
yes,
great.
And I do have a copy of it.
And you stated that in this declaration that Scott Scholler would provide NSDI a series of loans. Is that correct?
That is correct.
Do you recall when this was?
Boy, I think right up front, right in the beginning, and then through the process, especially towards the end of the first one, beginning of the second, and maybe the end of the second. It's been a while. I apologize.
It's just been over 20 years, so understandable. How did you become aware that Scott would be providing these loans?
Ralph Bagley kept the team informed. We had our Friday meetings, I believe, in the afternoon. Ralph was good at keeping everyone informed. It was important for all of us to know where we stood on everything.
Do you recall when you became involved with NSDI?
I want to say June of '99, something like that, right in the beginning.
Okay. Let's see. In your declaration, you stated that Scott would be paid back when sales began to pick up. How optimistic was NSDI and were you that sales would pick up and be able to repay these loans?
Well, we actually had a pretty good product for the day. We were pretty optimistic, honestly. Realistically, sales should have been much better. We just had issues with the Christian booksellers wanting anything to do with video games for whatever reason. We were optimistic.
And let's see, did you stated we were to keep our staff limited so that we'd be able to repay these loans. Is that your recollection? Were you constrained in any way because of this concern that you would have to repay the loans, NSDI would have to repay the loans later?
Constrained. I know there was a yes. I mean, I played a small part in coming up with the budget and telling the management what was needed as far as staffing. And yes, as things got tight, we had to do some cutbacks.
Okay, and then what caused NSDI to shut down, and when was this, to your recollection?
Well, I don't remember the year, but it was a while after our second title, and it was Mike Acton, who was the controller, I believe was his title, embezzled somewhat over $100,000 over the course of the couple of years he was there, and that's enough to take any small business down.
And then after NSDI shut down, did you have any continuing involvement with it?
I stayed on unpaid. I did tech support for the customers.
I'm sorry, I can't understand him speaking right now. Can you please repeat that answer?
Can you hear me? Is this better?
That's better, yes. Can you please repeat your answer?
I stayed on unpaid for, I don't know, 6 months or a year. I can't remember. I did tech support. I would field emails and phone calls from customers having technical issues with our game. Yeah.
Great. Well, thank you, Mr. Perkins. I have no further questions.
Thank you for your testimony, Mr. Perkins. I'm asking you to stay with us as I go to Mr. Cotino to see if he has any questions for you.
No, this is Brad Catino. No questions at this time. Thank you.
Thank you.
Thank you.
Judge Clutter, do you have any questions at this time?
This is Judge Clutter, no questions. Thank you.
Okay, and Judge Aiken, do you have any questions?
Judge Aiken speaking. I don't have any questions. Thank you.
Okay. Mr. Colabianchi, who will you be calling next?
If Mr. Caputo has entered, then I could call him. Otherwise, I could call Mr. Dietrich.
Okay, it looks like Mr. Caputo is not here today on this call, so let's bring Mr. Dietrich in. Mr. Colabianchi, I just want to let you know the number that was provided for Mr. Caputo is not correct, so OTA has been unable to reach him. Would you like to take a 2-minute recess and contact Mr. Caputo?
We could, or I could see if Scott might be able to contact
That's
him.
a great idea.
Scott should still be here. Yeah.
Mr. Scholler, can you do that, please? If you're interested in having him. Okay. I was being told that there was a thumbs up. Sometimes we don't see everything on the screen.
Okay.
So we'll move forward with Mr. Dietrich. Mr. Dietrich, I will need to swear you in so we can consider your testimony as part of the record. And you will remain under oath until the end of this hearing. Can you please raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth? Mr. Dietrich, I see a nod, and if you press *6 to unmute yourself, you can give me a verbal yes.
Can you hear me now?
I can hear you.
Yes.
Thank you. Mr. Colabianchi, please proceed.
Good afternoon, Mr. Dietrich.
Hello.
So Ralph Bagley testified that you were a member of NSDI's board of directors. Is that correct?
Correct.
Are you familiar with your declaration? It would be Exhibit 9.
I am.
Okay. You stated that you participated in a telephonic board meeting in 2001 where Scott Scholler offered to loan money to NSDI. Is that correct?
That's correct.
And you say that the loan was to be up to $400,000, but that amount turned out to be optimistically low. Do you recall how much Scott ultimately loaned NSDI?
No, I don't know the exact amount, but it was probably more than double than that.
And were these incremental loans as needed by NSDI according to your recollection?
They were.
Do you recall any other terms of the loans?
I don't.
Okay, thank you. You mentioned in your declaration there were two factors that contributed to the end of NSDI. The first factor was lower than expected sales. Can you tell me a little bit about that briefly?
Yes. I mean, I got involved because I had met Ralph, and I wouldn't typically get involved in something like this, but when he explained to me the market and that this market was needing this kind of thing, I really got excited about it. And my only concern was how good the game was, and as it ended up as a great game. Because I actually played it. I'd never played a video game before, and I love the game. The sales, to answer your question, the sales weren't doing well because a number of reasons. The market just wasn't, it was hard to penetrate a market that wasn't used to using games. And distribution is always it doesn't matter what business you're in, distribution is always a problem. And this was a startup, so I think just getting the word out there was just a very difficult thing, and it took time to build, and then finally in the end, I mean, it just kept taking more and more money to continue to get the thing to go, and in the end, the accountant, I can't, Michael Acton took a bunch of money, and that was it.
And what happened to NSDI after Mr. Acton embezzled from the company?
That was the end of it.
And when did you leave NSDI board of directors?
August of 2003.
Okay, thank you, Mr. Dietrich. No further questions.
Okay, thank you.
Thank you. I'm going to ask you to stay with us for a moment, Mr. Dietrich, while I check if anyone has any questions for you. Mr. Cotino, do you have any questions for Mr. Dietrich?
This is Mr. Coutinho. No questions. Thank you.
Thank you. Judge Clutter, do you have any questions for Mr. Dietrich?
This is Judge Clutter, no questions.
Okay. Judge Aiken, do you have any questions for Mr. Dietrich?
No questions from me. Thank you.
Okay. Mr. Colabianchi, I want to let you know that it appears that Dave Caputo has joined the hearing room. Mr. LaBelle, Chris LaBelle, is not in the hearing room. So if you would like him present, maybe Mr. Scholler can give him a call. It sounds like the number listed for Mr. LaBelle was not correct. Okay, so Mr.
Okay.
Colabianchi, would you like to move forward with your next witness?
Yes, with Mr. Caputo, please.
Okay. So let's make sure he's entered. And just keep in mind, I'm being told that Dan Hildebrand is also present.
Great.
Okay, I believe we have Mr. Caputo with us now. Can you press *6 and unmute and just confirm that you are Dave Caputo? Okay, we're looking for Dave Caputo, so I see a Dave's phone on the screen. And if that is Dave Caputo, please press *6 to unmute yourself and confirm that that is you. Okay, for whatever reason, he doesn't seem available right now. Mr. Colabianchi, would you like to move on to your next witness?
Yeah, I think you said that Dan Hildebrand was
I'm
in the
sorry.
room. Was
I'm
that correct?
sorry. Can you hear
we
me
have-
now?
Yes, is this Mr. Caputo?
It is.
Okay,
It wasn't *6. I just, this is the first time on a Zoom on a phone, so you're gonna have to excuse my ignorance.
that's okay. We can hear you loud and clear, and that's what I wanted to make sure.
Perfect.
I'm going to ask you to unmute yourself. Oh, you're still unmuted. Great. I'm going to swear you in, and you will remain under oath until the end of this hearing. Can you please raise your right hand?
Okay,
Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Colabianchi, please proceed.
Good afternoon, Mr. Caputo. Thank you for being available. Are you familiar with your declaration that you submitted? It's labeled Exhibit 8.
I am.
Great. Okay. Ralph Bagley testified that you were the director of marketing and sales at NSDI. Is that correct?
That is correct.
And do you recall when you were in that position?
It was early 2000s. I believe I left Enlightening the fall of 2003, if memory serves me correctly.
Okay. And now I'm going to refer to your declaration. You stated that NSDI finances were tight. How familiar were you with NSDI's financial situation?
Well, I mean, as far as financial situation, anything that I did as far as marketing and sales, I would submit excuse me. I would submit a proposal, and that would have to be approved from the board of directors before we could act on it. So as far as money, I knew there was certainly a limited amount of financing that was available. So anything that I, suggested or a direction we went would have to be approved.
Okay. You also stated that Scott Scholler will provide NSDI a series of loans. Is that correct?
That is correct.
How did you become aware that Scott would be providing these loans?
Well, Ralph had came to me. I was presently working with IMAX Bath Enclosures back in Tampa, Florida, and Ralph had came to me and told me what his plan was, and had asked me if I would be interested in a position, and I had stated to him I would consider it only after he had secured financing. he had stated there again that, he was in the process of working on financing. At a later time, he contacted me and said he had secured financing through a gentleman by the name of Scott Scholler. At that point, I agreed to come out to, Southern Oregon to lead off the marketing and sales for Enlightening.
Scott provide any further financing past that point?
I'm sorry?
Did Scott provide any further financing of NSDI past that point?
Yeah, amounts I couldn't tell you. However, I know there were multiple times that things would get tight, and Ralph would have to go back and secure additional financing through Scott.
Okay, and to your knowledge, was there in your declaration you stated there was a loan instrument memorializing the arrangement. Is that your recollection?
Could you define memorializing, please?
Sure. So was there a promissory note or a loan agreement that you were aware of with Scott?
I mean, if you ask me, I knew that there was an agreement. However, had I, seen that agreement, I don't recollect seeing it. And Ralph would, Ralph would inform us as far as what he had secured and what we had to work with.
And then briefly, when NSDI closed down, what were the reasons and when did that happen?
Well, on my part, I actually left before they closed down. They were in the process of doing that. The money had, the financing had ran out. There was no more financing to be had. Obviously, it was, hamstringing any marketing or sales proposals that I had to propose to try to accomplish what I was, tasked to accomplish. So I went ahead and left Enlightening and went to work for another company.
Do you recall which year that was?
I want to say I left Enlightening, like I said before, I want to say, and again, going 20 years ago, I want to say it was the fall of 2003.
Okay. All right. Thank you, Mr. Caputo. No further questions.
Thank you.
Thank you, Mr. Caputo. Please stay with us for a few more moments while I check in to see if anyone has any questions for you. Mr. Coutinho, do you have any questions for this witness?
This is Brad Coutinho. No questions at this time.
Thank you. Judge Clutter, do you have any questions for Mr. Caputo?
This is Judge Clutter, no questions.
Thank you. Judge Aiken, do you have any questions for Mr. Caputo?
Thank you. No questions from me.
Okay, and there are no questions from me. Thank you very much, Mr. Caputo. Mr. Colabianchi, would you like to call your next witness?
Excuse me, am I all finished, or I'm sorry for the interruption.
If you're able to stay in the waiting room, just in case there are follow-up questions, that would be really helpful.
Okay, all right. I'll put you on mute for now. Thank you.
Thank you so much.
You bet.
Mr.
This
Colabianchi.
is Mauro Colabianchi. Apologies. If Mr. LaBelle is available, I'd like to call him. If not, I can call Mr. Hildebrand.
Okay, I'm checking with our staff to see if Mr. LaBelle is available. Okay, it looks like right now we have only Mr. Hildebrand in the waiting room. So let's bring Mr. Hildebrand back in. I see his name here. Good afternoon, Mr. Hildebrand. Mr. Hildebrand? Can you hear me? He seems to have me on mute. If someone could give Mr. Hildebrand a quick call, that would be appreciated. Okay, let's go on a quick break just to allow, it looks like Mr. Scholler is actually calling Mr. Hildebrand. Okay. Mr. Hildebrand, can you hear me? Okay, so we will take a 2-minute break and hope that Mr. Scholler can get Mr. Hildebrand up to, so he can participate. So let's take 2 minutes, if everyone will go off the record, and if anyone can please turn off your video and turn off your audio as the live stream does continue.
Can you hear me through the Zoom?
Yes,
Okay,
I can.
I can hear you. Okay, so you're good now.
Yeah.
They're taking a quick break. Try to get back in.
Okay, all right.
Okay, if everyone is here, we can just go ahead and start. Mr. Hildebrand wasn't connected to audio, but it looks like you can hear me now. So
I can.
Okay, great. I did say a 2-minute break, so we will make sure everyone is here before we go on the record.
Sure.
I see Judge Aiken is here and Mr. Cotino is here. Mr. Colabianchi, are you with us?
Yes, Your Honor, I'm here.
Okay, and Ms. Mosk, are you also on the Zoom again?
Yes, I am.
Okay, great. We're just going to do another reminder to everyone that we do a little pause before answering a question, just so that we're not overlapping each other. And Mr. Hildebrand, I do need to swear you in, so we will go back on the record at this point.
Okay.
Mr. Hildebrand, thank you for raising your right hand, and I would like to ask you if you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth.
I will.
Thank you very much. And Mr. Colabianchi, please proceed when you're ready.
Hi, Mr. Hildebrand. Thanks for being available. I would like to direct you to Exhibit 13. This is your sworn statement. Are you familiar with this document?
Yes, sir, I am.
Are you the president of CC Complete?
I am, and Chief Operating Officer.
Could you briefly explain what CC Complete is, what kind of business it is?
We're software as a service. We write applications and host them on our own equipment, and then we charge our customer base to access and use this very specifically designed software and applications.
Could you briefly explain how Scott Scholler is related to CC Complete?
Scott Scholler was one of the original founders of CC Complete in 1995 or 4 or something like that, and was he is a primary stockholder in the company and is CEO of CC Complete.
According to your letter, you state that CC Complete wired money to Enlightening at the direction of Mr. Scholler. Can you please briefly explain the circumstances surrounding those wires and why CC Complete did this, just briefly?
I can. Now, this happened before my time, and so what I had to do is have our accountant go back and review the accounting records. I joined in early 2002, but for the sake of expediency is our understanding that in lieu of the company sending money to Scott, he asked that we transfer monies owed him to Enlightening. And that's the foundation of those transfers.
Great, and no further questions. Thank you.
Thank you for your testimony, Mr. Hildebrand. I'm going to ask you to stay with us for a few moments. I'd like to see if Mr. Cotino has any questions.
This is Mr. Cotino. No questions at the time.
Judge Clutter, do you have any questions for Mr. Hildebrand?
This is Judge Clutter. I just had one quick question for Mr. Hildebrand. You said that you joined in early 2003. Is that correct?
2002.
Oh, sorry, 2002. Okay. So, could you please explain the relationship between CC Complete and Enlightening, specifically with the Mike Acton and Bill Glenbow, and why they were, what the relationship between the two companies were and why those employees were sent to Enlightening.
Right. So Acton was the controller of the company when I came on board. He didn't last very long after I got there, but he was the controller, and he also served as, I believe, controller for Enlightening. But mind you, I really don't have a lot of information about Enlightening other than it was one of Scott's other entities that he was involved in, and Acton served as a dual role working for CC Complete and for Enlightening as a controller.
And was Bill Glenbow also, what was Bill Glenbow's name, and was he a CC Complete employee?
No, I was never familiar with a Bill Glenbow at CC Complete.
Okay, no further questions. Thank you.
Thank you, Judge Schlatter. Judge Aiken, do you have any questions for Mr. Hildebrand?
Thank you. No questions from me.
Okay, Mr. Hildebrand, I just want to ask for some clarification on your testimony. You testified that you were not at the company when CC Complete provided funds or transferred funds to Enlightening. Can you reiterate for us how you came to that information, and did you personally see records that led you to this claim?
Yes, I personally saw records. What I had was our then accountant go back and look at all of the transfers to Scott or on Scott's behalf, and went through and did a complete, not audit, but an exhibit to show me exactly those transactions and the records that they're in the accounting files. So there's a ledger that records every one of those disbursements to Scott or on his behalf.
Okay, thank you.
And the bank account corroborates that, by the way.
Thank you, Mr. Hildebrand. And I believe that we have no more questions for you. So if you don't mind staying in the Zoom in the waiting room, that would be helpful in case there are later questions.
Okay, so I'll just mute and.
Yes. And you can turn off your video. Okay, Mr. Colabianchi, I'm being told that Mr. LaBelle is in the waiting room. So would you like to call him next? You have a couple minutes.
Yes, please. I would like to call Mr. LaBelle, Your Honor.
Okay, so this is Chris LaBelle. Can you please press *6 or otherwise unmute yourself and let me know that you are here? I see Mr. Chris LaBelle's name. Can you please let us know that you are here and that you can hear me? Okay, so Mr. LaBelle, if you are joining us not through the phone, but through Zoom, you might have to click unmute, the bottom left of your screen. And if you're calling in, you would press *6.
There we go. Can you hear me now?
We can hear you.
I apologize about that. Let's move forward. What can I do for you?
Okay, great. So first of all, I'd like to confirm your name, please.
Chris LaBelle.
Okay, great. I'm going to ask you to raise your right hand so I can swear you in. You will be under oath until the end of this hearing today.
Okay.
Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, Mr. Colabianchi, please proceed.
Hi, Mr. LaBelle. Thanks for being available. How do you know Ralph Bagley and NSDI?
We were co-tenants at a building, a warehouse at 727 North Central Avenue, Medford, Oregon.
And what kind of items was Ralph storing at the warehouse?
To my knowledge, he had software, gaming software, games, things of that nature.
Could he have been storing documents and business records there?
Highly possible. Seemed like most of his operation was there.
What happened to these items?
To my knowledge, there was I remember there was a very large, extremely heavy snow event. The roof at the warehouse is pretty flat. You know, it's a pitched roof, but it's flat. And it failed in many spots. I remember the landlord had to basically replace the whole roof. And so lots of water. I had some water damage, and I know that Ralph did as well.
You said you had some water damage. How badly were your products damaged?
It depends on where it was with us, but I had, a lot of my cases, I'm a beverage distributor, so a lot of my cases are in flats of cardboard, and I had to repack a lot of cases into new cardboard boxes because of the amount of water that came through in various spots.
Great. No further questions. Thank you.
Thank you.
Thank you, Mr. LaBelle. If you can stay with us for a moment, I'm just going to check and see if anyone has any questions for you about your testimony. Mr. Cotino, do you have any questions?
This is Mr. Catino. No questions at this time.
Thank you. Judge Clutter, do you have any questions?
Judge Clutter, no questions. Thank you.
Judge Aiken, do you have any questions?
Also, no questions from me. Thank you.
Okay, and I also have no questions. So thank you, Mr. LaBelle. If you don't mind staying in the waiting room for a bit, just in case questions come up later, that would be helpful. Okay, just want to check in with the judges to see if there are questions for any of the witnesses who have testified so far today. So Judge Aiken, do you have any other questions for witnesses at this point?
No additional questions from me at this point.
Thank you. Judge Clutter, do you have any additional witnesses for any of the, do you have any questions for any of the witnesses at this point?
Yeah, I do not have any additional questions. Thank you, Judge Rossi.
Okay, and I'll double check with Mr. Cotino. Do you have any questions for any of the witnesses at this point?
This is Mr. Catino. No questions at this time. Thank you.
Okay. In that case, Mr. Cotino, we are ready for your presentation. You will have 15 minutes. Please begin when you're ready.
Give me 1 second to pull up my documents and I'll be ready.
Sure.
Good afternoon. My name is Brad Catino, and I represent Franchise Tax Board in this matter. There are three main issues in this appeal. The first is that appellants have not shown that the proposed assessment, which is based on federal adjustments, is erroneous. Specifically, appellants have failed to provide consistent information and documentation demonstrating that they're entitled to the non-business bad debt deduction claimed for the 2003 tax year. The second issue is that appellants have failed to show that the accuracy-related penalty should be abated. And the third issue is that appellants are not entitled to interest abatement because appellants significantly contributed to the error or delay during protest by failing to notify respondent when their federal audit had concluded. To the first issue. In this case, FTB assessed additional tax based on federal information, which reflected that the IRS disallowed non-business bad debt deduction. Appellant's federal account transcript and audit file do not reflect that the federal adjustments were ever revised or abated. In regard to the non-business bad debt deduction, Income tax deductions are a matter of legislative grace, and a taxpayer who claims a deduction has the burden to maintain records that are sufficient to establish that amount of that deduction. Internal Revenue Code Section 166, to which California conforms to, allows a deduction for a business or non-business debt that has become worthless during the tax year. There are two sub-issues in regard to the non-business bad debt deduction. First, whether there was bona fide debt, and second, whether the debt became worthless during the 2003 tax year. To the first sub-issue, there's no bona fide debt because there was no formal loan instruments. 2, nothing that reflected a lender-borrower relationship. And 3, the economic realities of the transaction would have not been taken on by a prudent outside lender. To the first subpoint, the form of the instrument. The absence of any type of formality typically associated with a loan, such as a written loan agreement, a promissory note, or a demand for repayment, supports the conclusion that the advances were contributions to capital rather than a loan. Appellants allege that due to a winter storm, embezzlement by a former employee, and a hard drive crash, there are no promissory notes, no board minutes, no financial statements from the 2003 tax year, no loan repayment schedule, no contemporaneous email exchanges, or any other formal loan documents to reflect a bona fide debt. Instead, appellants have provided several witnesses and testimony from appellants to establish that the loans existed. However, courts have held that uncorroborated oral testimony is insufficient to satisfy the taxpayer's burden in an equity versus debt determination. Today, appellants have demonstrated some of the difficulties of relying on uncorroborated oral testimony. For instance, during his testimony, Mr. Bagley testified that the sales of NSDI's video games were actually growing in 2003. While appellant husband testified that the company was beginning to show signs of stress in early 2003. Moreover, in his testimony today, appellant husband seems to allude to the fact that the payments of the loan would only occur when the company was on sound financial footing, with no definitive date certain, which seems contrary to the nature of the short-term loan. Further, as stated today during his testimony, appellant husband is a sophisticated business person. He has served as an investor for 4 separate companies, some of which have become IPOs and are still in business today. As a sophisticated investor and business person, appellant husband knew or should have known the importance of keeping proper record keeping, especially considering his loan of over $1.2 million. If appellant husband intended for those funds to be repaid, he had an obligation to maintain records that reflected payment schedules, promissory notes, board minutes, or demands for repayments. There's nothing in the record that reflects after one of the unfortunate events that occurred, such as the embezzlement, such as the snowstorm, such as the hard drive crash, that appellants took any action to reconstruct or request declarations to corroborate the loans provided by NSDI. The lack of formal documents, including a promissory note, and more importantly, any demands for repayment, reflect that the funds provided were not loans. To the second sub-issue, intent of the parties. In appellant's reply brief dated April 25th, 2022, appellants state that there were 2 lending events. And as they have stated today, the first lending event was a loan of over $800,000 that was made in the year 2000, and that was to be repaid 1 year later. The second lending event were short-term loans, which comprise the non-business bad debt deduction that are at issue in this appeal. There's nothing in the record that reflects that the first lending event resulted in a repayment of the loan. There's also no demand for repayment regarding the first lending event. Despite the lack of repayment of the first loan, appellant husband proceeded in 40 separate transactions over a 2-year period to distribute $1.2 million to NSDI. There's no indication that appellants ever requested repayment, requested that the terms of the agreement be amended, or that any of NSDI's assets be liquidated to repay the loan. Given the lack of evidence reflecting repayment and a demand for repayment, it is fair to assume that neither party intended that the funds would be repaid at the time the funds were issued. To the third sub-issue, economic realities. In this case, the economic realities reflect that a prudent outside lender would have not entered into the same arrangement that appellant husband did with NSDI. As explained earlier, and to reiterate, appellant husband made an initial loan of $800,000 that appears to have never been repaid. Yet appellant husband allegedly proceeded to loan another $1.2 million in several transactions over a 2-year period, despite no evidence that the funds would or could be repaid by NSDI, considering the default of the initial loan. No prudent lender would have continued to advance contributions when the business entity repeatedly and continuously defaulted on the terms of the purported loans. Based on the lack of formal loan documents, the lack of intent by the parties, and the repeated defaults by NSDI, there was no bona fide debt, and thus the IRS properly disallowed the non-business bad debt deduction for the 2003 tax year. To the second sub-issue, appellants have not demonstrated that the debt became worthless in 2003. Appellants bear the burden of proof to show that the purported loans became worthless in the 2003 tax year. To determine whether a debt is wholly or partially worthless is based on all facts and circumstances, including the financial condition of the debtor. In Bishop v. Commissioner, a U.S. tax court case, the court found that testimony alone is insufficient absent documentary evidence to corroborate that the debt has become worthless. For example, the Bishop Court stated that while the lender himself may have concluded that the debt had become worthless, there was no financial and cash flow statements or earning reports that would corroborate the lender's conclusion in the Bishop case. Similarly, while appellants may have taken Mr. Bagley's September 22, 2003 letter to conclude that the debt had become worthless, there are no financial statements from the 2003 tax year, no cash flow projections, no earnings report that support appellant's conclusion. The record also reflects that the debt did not become worthless until much after 2003. Exhibit L to respondent's reply brief, dated March 17, 2021, reflects that NSDI did not dissolve until late 2009, 6 years after Mr. Bagley's letter. Exhibit M to respondent's reply brief reflects several articles where Mr. Bagley touts NSDI's success, and more importantly, that the demand for Christian video games and the potential growth for years to come. Specifically, there's a question and answer interview with Mr. Bagley that is dated July 19, 2005, that can be found on Exhibit M, page 22. In that question and answer, there's a question regarding the Christian game business. In response to that question, Mr. Bagley states, "The Christian game business is outstanding. My team is currently negotiating with a few different Christian authors to do games based on their books. Those will be $4 to $6 million projects." There's a subsequent article from the LA Times dated May 10, 2006, that is attached to Exhibit M. At the very end of page 18 of Exhibit M, there is a line that states, "Bagley saw demand for his games skyrocket during last year's holiday season, presumably the December 2005 holiday season." Moreover, Mr. Bagley even touted the past success of NSDI in the investor presentation in the financial statement provided in Exhibit 16, page 7 by appellants. In that financial statement, it shows that the company has sufficient assets to pay all or some of the alleged loans owed to appellant husband. As testified by Mr. Bagley today, the sales of the company were growing in 2003. As testified by appellant husband, instead of demanding repayment after receiving Mr. Bagley's September 2003 letter, he instead decided to have the company continue on, presumably so that him and Mr. Bagley could eventually return the company to sound financial footing. The continuation of NSDI for multiple years, Mr. Bagley's statements about the future prospects of Christian video games, and appellant's lack of demand for repayment and lack of record keeping all demonstrate that the debt could not be considered worthless by the end of the 2003 tax year. To the second issue regarding the accuracy-related penalty. During the pre-hearing conference, appellants stated that they were not contesting the computation or imposition of the accuracy-related penalty, but rather assert that the accuracy-related penalty should be abated in conjunction with withdrawal of the proposed assessment. Today, appellants allege that the accuracy-related penalty should be abated due to a reliance on a financial advisor, but concede that they have no documentary evidence to support this contention. As explained in its opening brief, respondent followed the IRS's imposition of the accuracy-related penalty for a substantial understatement of tax, and there is no evidence in the record to support abatement of the accuracy-related penalty nor withdrawal of respondent's proposed assessment. To the third issue regarding interest abatement. Appellants have failed to establish that they are entitled to abatement of interest on the proposed assessment because they significantly contributed to the delay from the issuance of the notice of proposed assessment in 2009 to when the notice of action was issued in 2010. As reflected in Exhibit G on page 5 of respondent's opening brief. In appellant's protest letter, they requested that the matter be deferred based on a pending matter with the IRS related to the proposed assessment. During the deferral period, respondent followed up with appellants on multiple occasions, but the record reflects that appellants never responded. Due to appellant's initial request for deferral and the subsequent non-response to FTB's letters to inquiries related to the federal matter, appellants significantly contributed to the error or delay, and thus interest cannot be abated under California Revenue and Taxation Code Section 19104. In conclusion, based on the evidence in the record, appellants have provided inconsistent, non-contemporaneous documentation that fails to meet its burden to establish that they're entitled to the non-business debt deduction claimed for the 2003 tax year. As such, respondents' proposed assessment should be sustained. I'm happy to address any questions or concerns the panel may have at this time.
Thank you, Mr. Coutinho. I'll check with my panelists if they have any questions. Judge Aiken, do you have any questions for FTB?
Judge Aiken speaking. I do have one question. So, Mr. Coutinho, I understand FTB's position is both that it's not a bona fide debt and also that it was not worthless in 2003. On the first of those positions, if it is not a bona fide debt, what is FTB's position as to what these contributions, assuming they were made, what are they?
It appears from the first loan that there was some equity that was given to appellant husband. I believe it was 20% as testified today. It appears from the letter that was dated September 2003 from Mr. Bagley that essentially appellant husband would then be the owner of the corporation based on the debt that had been accrued. So it appears that there may have been equity. Based off the testimony today, it appears that they were not loans based off the lack of demands for repayments and that the company was going to continue on and pay other vendors instead of appellant husband. So it could potentially be just appellant husband believing in the company and hoping from as he testified today as a parent that hopefully it would succeed and potentially penetrate a larger market than it had.
Okay, and as a follow-up, I guess I'm wondering if it's not a bona fide debt, if it would be additional paid in capital or equity, to which IRC section 165G could potentially apply. Again, this would be, I'm not addressing the issue of when it became worthless. I understand your position on that. I just wanted to address whether or not this could be potentially, if not a debt, an equity interest to which IRC section 165G could apply.
Thank you. Give me 1 second. As
Absolutely.
As stated in respondent's additional brief dated November 18th, 2022, appellants have not shown that they qualify as a capital loss under IRC section 165G. Specifically, they haven't provided any evidence of any stock certificates, any registered security that would reflect that he received the stock purchase from this. Second, there's a lack of adjusted basis, again, due to the inconsistent statements regarding the loan amounts and when it was provided. And then third, I think more importantly, it appears that a condition to qualify with that the security became worthless. I understand that's not quite your question. It was more just whether the first two, but as stated earlier, respondent's position is that the debt didn't become, or the security did not become worthless in 2000. Thank you.
Understood. Yeah, I do understand your position on that, and I don't mean to shortchange you on it. I just didn't want to, my question wasn't to that. But that answers my question. Thank you for that. I don't have any additional questions.
Thank you, Judge Aiken.
I'm sorry.
Judge Clutter, do you have any questions at this time?
Oh, sorry, was there a question from the
I'm just wondering if you have any questions at this time for FTB.
I do not have any questions for FTB.
Okay. Mr. Colabianchi, would you like to make a final statement, a rebuttal to FTB's presentation?
Hi, Your Honor. This is Mauro Colabianchi. I did want to address a couple points here. So Mr. Coutinho said that the form of the instrument was not there for it to be a bona fide debt, and that uncorroborated witness testimony is not enough. Well, I agree that we don't have a copy of the promissory note or the meeting minutes where these loans were discussed. We do have testimony from multiple witnesses that corroborate each other. We also have contemporaneous records that were provided, notably the profit and loss statement, showing that these loans were being treated as loans in the internal company records. Then Mr. Coutinho also discussed the intent of the parties and that there was no demand for repayment. The problem with that is Scott knew that a demand such as this would be futile, and that the only assets remaining in the company in 2003, when the debt was worthless, was game stock that would be difficult for Scott to get any funds out of. Mr. Coutinho mentioned the economic reality. He said no outside lender would provide loans to the company, when in fact the company did have an outside lender. It was that Home Valley Bank, and this was contemporaneous with when Mr. Scholler was providing these short-term loans. The Home Valley Bank line of credit was in 2000. It was renewed in 2001. From 2001 to 2002, the interest rate was being lowered, consistent with the market interest rate. And then it was finally canceled in 2002, June, but it's unrelated to their specific client. It was because they had been bought out by a different bank that they don't want to offer that product anymore. But Scott's loans started in 2001. So contemporaneous with Scott's loans, there was an outside lender providing funds to an SDI. As for worthlessness, Mr. Coutinho says that it can't be based on testimony alone, but we do have several objective indicators. We have the embezzlement of Mr. Acton testified or corroborated by an exhibit. See, I think it's exhibit 3, talking about the embezzlement. We have witnesses corroborating that event. We have IRS records showing that the business had payroll in 2003, in the beginning of 2003, and then towards the later part, they didn't. And then the rest from 2003 to 2009, there's no payroll. So it's a strong indicator that the business was defunct. Mr. Coutinho mentioned that the business was not technically dissolved until 2009. We think this is just a ministerial task that wasn't completed by Mr. Bagley, and really it's not very significant when compared to the payroll tax records, which are more on the ground, and something that, you know, if you're not paying payroll tax, you probably don't have employees. The articles that Mr. Coutinho mentioned, some of them are misleading. I think a lot of it is more aspirational on Mr. Bagley's part. And then, for example, they mentioned something about the Left Behind series, but Mr. NSDI never had a contract with Left Behind. There were some inaccuracies in the articles that I note in my briefs. As far as the penalty, this is it's an accuracy-related penalty, and my clients relied on their professional, both Gay and Scott testified to that, and I think it's reasonable to see Mr. Bagley's letter dated in 2003 and say, well, if any tax professional looked at that this debt that he's referring to, he's saying it's worthless now in 2003, so it needs to be declared on the taxes. I think that would be a reasonable position to hold, and their reliance on their tax preparer was reasonable as well. As for the interest, while it is true that Mr. Scholler was trying to get an audit reconsideration with the IRS and had asked the franchise tax board for more time, it seems the last time the franchise tax board checked in with him was in 2016, several years after he had already filed a protest. And so it seems like even at that point, it was 7 years after the protest, but franchise tax board waited another 4 years with no contact to issue the notice of action. So we do feel like that interest should be abated. If I have any more time, I wanted to see if Scott might have anything to add as well.
We are actually out of time. So
Okay.
I'm going to check with my co-panelists and see if they have any final questions for yourself or for FTB or any of the witnesses today. Judge Clutter, do you have any questions?
This is Judge Clutter. No questions.
Okay. Judge Aiken, do you have any questions?
I think I just want to ask one quick question. So I asked Franchise Tax Board if it's not a bona fide debt, whether it could potentially be a worthless security pursuant to IRC Section 165G. I just wanted to give appellant an opportunity to respond to kind of that same question.
Thank you, Your Honor. Well, our position has consistently been that it's a bad debt deduction. My client is no longer a California resident, so a capital loss would, in this sense, would not be useful. I know that's not a legal argument, but just the practicalities of it. There was a brief, and I do believe if you follow it, there are some factors that are similar between the bad debt deduction and the worthless securities. The worthlessness, I think, is the same analysis. Obviously, we think it was worthless in 2003. Whether it was a security, There was, I believe Mr. Coutinho said that there was funds for security that was in the first loan that wasn't actually considered in the calculation of the bad debt deduction. We do think there's an argument to be made. It could be a worthless stock capital loss, but again, it doesn't really help my client. And then I think you could say that it was a worthless stock if it's not going to be a bad debt deduction. Yeah, I don't know how deeply you'd like me to go into it, but I think it could be, yes.
You answered my question. I do understand that your primary position is that it's a bona fide debt, and a bad debt deduction is proper under IRC section 166. I just wanted to give you an opportunity to respond to the same question I had asked, and you addressed it. So no further questions from me. Thank you.
Thank you, Your Honor.
Okay, and I have no questions either. So I'm going to now go to a procedural matter and check with Mr. Coutinho. I don't know if you have decided whether you would like to provide any post-hearing briefing on exhibits 16, 17, and 18.
Yes, I would like to provide. This is Mr. Coutinho. I would like a post-additional briefing. Thank you.
Thank you. Okay, in that case, we will grant that, and the record will be held open until next Friday for additional briefing on the issue of proposed exhibits 16, 17, and 18. Following additional briefing, yes, Mr. Coutinho.
Did you say just 1 week?
How much time do you need?
Can I get a month, or can I get 2 weeks, or what's the?
I think 2 weeks. We can do
Okay.
2 weeks because this is, their last minute briefs,
Okay.
last minute exhibits.
Okay.
Okay. Okay, so we'll hold the record open for 2 weeks, 2 Fridays from now, for additional briefing on the issue of proposed exhibits 16, 17, and 18. Following the additional briefing period, OTA will close the record in this appeal, and OTA will issue a written opinion within 100 days thereafter. This is the last appeal of the day. So this hearing is adjourned, and this concludes the hearing calendar for today. Thank you to everybody who provided arguments and testimony, and thank you to Ms. Mosk for our stenography work today, and thank you to the OTA team who's been working so hard behind the scenes. Have a good day.
Thank you. Have a good day.
Thank you, Your Honor.
Thank you.